Just call call.
Any mentioning not in the list? Any mentioning in the list? Item number one. Theorem DV3 of 125.
So,
I don't know.
conviction is under which section?
10 of Fox.
So it is below 7 years.
Yes, sir.
Then it has to go to the single bench. Do you have the judgment with you?
No, he's for the state.
Yes, but
He's for the.
you are for the petitioner. Do you have the judgment? The conviction order, do you have with you?
Has not been
That
released.
No, it is not. Can we have a copy of the same?
Fine. Let me, item number 7.
বলে দেবো সাহেবের কাছে যাবে। শোনো, ফাইলটা নামিয়ে দেবে, ওই ডিপার্টমেন্ট ওই নমেনক্লেচারটা চেঞ্জ করে দেবে, আর ডে আফটার টুমরো সাহেবের বেঞ্চে দিয়ে দেবে।
Item number 2. WBC 12 of 925.
Who is opposing him?
Alright, Mr. Rakesh will appear in this matter. This pertains to electricity department matter. He
Will appear. Why he's not here?
is not here, my lord.
I have already sent the hand, they received my hand, the authority.
Madam, please come to the judgment of justice. It's page 171. No, sorry, this is the first, not this. That is at page 244. This third page, internal page 3, the para before the penultimate para, after going through. Please kindly place that after going through.
Published date, published date 12 December 1975.
Hmm.
So finds that either post for promotion to chargement status. There were further appears they found that the diploma in electrical mechanical engineering cannot be said to be an essential qualification in view of the expression or use in clause 2 and the senior number 13 and 14.
Can you explain this? Because the earlier judgment of the Justice Kalgupta, that was in Nabin matter, please take it up. In that, the issue was that there was a misquotation of the circular, that not was missing.
In the matter there before the honorable high court in that matter
Hmm.
of chargement, they were having diploma or degree in engineering. So the court felt that they should be granted the scale of chargement. There was no dispute with regard to that at that stage. These people,
They had diploma
they did,
before Justice Kalgupta.
yes. They
Then why were they being denied?
These people have been denied because these people, they don't have diploma.
Right.
Now, what happened in between, what happened? The government of India, because that was an engineering cadre. Now, the engineering cadre includes the post of chargeman. It also includes the post of junior engineer. Government of India has taken a decision that non-diploma junior engineers, those who do not have degree or diploma, they also should be granted the same pay scale.
But here it is the chargeman, that is the feeder, that is the feeder to junior engineer.
They are almost equal. Chargeman is equal to junior engineer, not feeder.
Then-
Chargeman post is not a feeder post of junior engineer.
Feeder was the feeder post of chargeman.
Yes.
So chargemen, when they were appointed, they were not granted the scale on a purported plea that you do not have a diploma.
No. When they were, because there was certain chargemen who were having diploma.
No, that is inter se discrimination. We are trying to which
Now,
this.
granted. When the chargemen were appointed, neither the diploma holder nor the non-diploma holder were granted that particular pay scale. None of them were granted.
At the time of the
Initial appointment of the chargeman.
Hmm,
No.
No. Very good. Then what prompted the tribunal to reject the case, which was set aside by the High Court through the judgment of that division bench?
This division was earlier.
Earlier.
That because the chargemen they were appointed in terms of a particular recruitment tool, where the pay scale was a fixed pay scale, and therefore those persons, whether they are diploma holder, not diploma holder, they are not entitled to it. I challenge before this honorable court, I have explained that the Fifth Pay Commission has recommended that the engineering cadre, when diploma holders of engineering cadre, they should be granted the higher pay scale. I submitted before this court, and this honorable court has also looked into the recommendation of the Fifth Pay Commission. And this court has said that as the chargeman also falls under the engineering cadre, and they should be granted the same pay scale as that of the other engineering cadre, they should be granted their pay scale because they are diploma holders. There was no dispute with regard to diploma holders. Now, after that, what happened? The authorities extended that pay scale to them. Diploma holder were getting the higher pay scale, non-diploma holder chargemen were not getting that particular pay scale. Same was the position of junior engineers. Junior engineers who were holding diploma and degree, they were getting it. Non-diploma, they were not getting. Then government of India has issued an order.
Yes, come to that. That is, I think, at page 201. Are you talking about this 220? This circular was there prior to delivery of judgment in that WPCT 594.
290.
Yes, place it.
Problem was that, Your Lordship, in that set of matters, non-diploma holders were not there.
No, right, we under,
Issue.
no, that was not talked about in the subsequent order where Justice Bhattacharya delivered that order.
There, the Justice Bhattacharya has discussed about this particular thing.
We understand. Now, in this, there was a that non-diploma holder would also be entitled
Yes.
where it is seen to the non-diploma, right?
Right. We decided to grant upgraded scale of pay.
Hmm.
Is this to the non-diploma holder junior engineers of the Electricity Department of Administration?
So on the basis of this circular, you went up, you made a representation.
I made a representation.
Tribunal rejected it.
Yes, first the authorities rejected it,
Hmm.
and then tribunal rejected it,
Hmm.
and then I came before this honorable court. This honorable court found that yes, this particular thing has to be given consideration because when the junior engineers, non-diploma junior engineers falling in the same engineering cadre, they were also not granted that this particular pay scale on the ground that they were non-diploma holders, and thereafter the government of India has taken a decision that junior engineers, non-diploma holders should be granted that this particular thing, why it should not be applied to the chargemen of the same department, because they were also considered under the same engineering cadre.
Under the same engineering cadre, there were chargemen as well as junior engineer.
Contains
Yes,
chargemen, all those they are under that cadre.
where from we will find that they were on the same cadre.
Yes. I have referred to the recommendation of the Pay Commission where it has been held that these are the cadre and where that particular recommendation was applied in the case of the chargeman and the higher pay scale was granted. That recommendation was for engineering cadre. It was applied by this honorable court and thereafter the chargeman working in the electricity department, the same department, holding diploma, they have been granted the pay scale.
Oh. Now, please explain to us this paragraph. Where is this recruitment rule of 12 December 75? Where is it? Your order, your order also does not reveal the consideration of the two prima facie finding of the High Court. Two prima facie findings were there. Upgraded scale of pay as paid for budget could not have been rejected on the ground that they are non-diploma holders in view of the circular of 21st August 2008. Did you have the opportunity to go through it?
No, because I am not the advocate in this. Mr. Rakesh Kumar is the advocate.
So where is Mr. Kumar?
No, he is, my lord, I think on his legs before my lord, some court, my lord. That's what.
Legs means there is only one court
No,
now.
through VC, my lord, I think he might be on.
He has not come.
He came, my lord, but on VC, my lord, I think he's appearing before some court.
So please ask him to come and finish off the
My
matter.
lord, asking.
All in all,
Hmm.
tribunal has done. Tribunal has decided the matter on the basis that that particular order is applicable to the junior engineer, that cannot be applied to the chargeman. That is what is to be discussed by the tribunal after the order of this honorable court.
Which
Why it should
circular?
not be applied?
Which circular? That is page 160.
119 was referred by this honorable court.
Yes.
That this particular order,
Hmm.
particular order is applied to junior engineer. Why it should not be applied to the chargeman?
Because they are there, but they are under the same cadre. Where from we will get it?
Judgment. What judgment of this honorable court?
Show us that.
Yes.
Then what was the difference between them? Why this nomenclature was different? Chargeman and junior engineer.
Cadre is same, those are different. Number of, this is engineering cadre. In engineering cadre, there will be junior engineer, assistant engineer, executive engineer,
Please
chartered.
show us the earlier order of the High Court. That is at page 171.
One second. My dear, what should be kindly see here, the second here?
Fifth Central Commission recommendation.
Yes, that is-
Which portion you are referring to? You have carefully considered. Yes.
Petitioner for being the group of charge and electricity department and among governance and administration. Fifth Central Pay Commission constituted by the government of India submitted its recommendation in the month of January 1996. Clause 50.23 of the above recommendation prescribe division scale of pay structure for engineer subordinate cadres possessing diploma in engineering. This is the. We have carefully considered the demand of the federation and the views of the administrative ministries, departments in the light of our general approach on the pay scale of different professional technical groups of staff and existing relatives between technical and non-technical categories. We have as a general rule decided to improve the initial requirement pay scale of diploma engineers in government. We accordingly recommend that following pay structure for engineering subordinate cadres. Now this is one. Some of these are graduates in engineering, others are diploma holders. Now.
You come within those.
Yes, that chargemen, they were coming before engineering subordinate cadres.
Hmm.
Now, Your Lordship, I'll just place it, Your Lordship, Your Lordship will get the answer. The Andaman Nicobar administration took up the issue of finalizing left out case of granting the benefits of the above pay structure by virtue of the communication dated December 26, 2001.
Where is this circular? December 26. December 26 earmarked the two different categories. That circular has been quoted in the subsequent order. Page 43 of the writ petition. 26 December 2001.
I think it is their part of the.
It is there, it is there. This 26 December, this reference you will find in the tribunal order which you have impugned before us. That we will get. No, sorry. No, this anyway, you no. Query is kindly come to 257. Sorry, you are placing 170. No, you can finish off that and come. Then say 100 and
170.
just about. Yes, since note was.
Since no step was taken by the authorities to extend the above benefit in favor of the petitioner, they filed an application before the Civil Administrative Tribunal, Calcutta, and certificate portal getting one number 3, and the same was disposed on 12th April 2010 with the direction upon the respondents to take a decision with regard to the above mentioned petitioners. The Andaman Nicobar administration in turn informed the petitioner by an order number this dated this that above matter had been decided by respondent number 1 before filing the above application by an order dated 17 December 2009, passed by the Undersecretary Government of India Ministry of Power. The petitioners filed another application before the Central Administrative Tribunal of Calcutta and Circuit of Blair, bearing 4 number this, and after consulting the advance of the petitioners on merit, the learner tried to discuss the above application on 27th August 2010. Hence, this petition. We have heard the learner counsel appearing for the respective parties carefully, and we have taken into consideration the facts and circumstances of this case. It is not disputed that respondent number 1 rejected the claim of the petitioner on the following grounds.
Right. This ground, first one, diploma in India was not an essential. This not has been, this is a typographical error. This one.
That is the reality. The diploma in engineering was not an essential qualification for post of electricity department. That is a reality. It is not an essential qualification. Nowhere in the recruitment rule, diploma in engineering is made as a essential qualification for the post of chargeman. No. The ministry has declined to give it, extend that recommendation, because the ministry found that the chargemen who have been appointed in electricity department, they were not required to have any diploma. So there are chargemen who are not holding diploma in engineering or degree in engineering. So under such circumstances, how this particular recommendation can be extended to them? Because these people, they are not having diploma. The recruitment rule says so. Maybe the chargemen who are appointed, they will be having the qualification of diploma or degree. Maybe. But recruitment rule says that it is not required. If it is not required, then in that case, how this recommendation can be extended? That was actually the ministry's decision. Now, the educational qualification required for the post of chargeman in electricity department was lower than the post of chargeman in motor transport department. So these were the two criteria. In the motor transport department, for the post of chargeman, diploma in engineering was essential qualification. But for electricity department, diploma in engineering was not an essential qualification. Now, taking into consideration above terms, the tribunal held that the decision-making process responded on one procedure and after producing the recommendation of the Central Pay Commission in respect of engineering subordinates holding diploma in engineering, we find that the grounds shown in the order dated this were
They are all were diploma holders.
They were holding diploma. So court said whether diploma in engineering was an essential qualification in the recruitment rule or not is not at all required to be looked into. What is to be seen whether the persons who are falling in the engineering cadre, the chargemen, they are holding a diploma or not. If they are holding a diploma, they should be granted. So accordingly, the chargemen who are
Now, these persons are not diploma holders.
these persons are non-diploma.
No.
They are not diploma holders. So that is the reason why I am relying upon the government of India's decision, where the government of India has decided to pick one of the cadre, one of the posts.
Where is that memo you showed us?
2019. 219, I'm sorry. 219.
Oh,
They picked one post from the engineering cadre.
please place it.
Yes, sir. I am directed to refer to the Andaman and Nicobar Administration letter number this, and letter number this, and the above subject, and to say that the proposal of the administration regarding upgradation or scale of pay of non-diploma junior engineers in the electricity department from pay scale of this to this has been reconsidered in this ministry.
Decided to grant the upgraded scale.
It has been decided to grant the upgraded scale of pay of 5,000 to the non-diploma holders in the engineers of the electricity department of administration.
So placing reliance upon this, you made the representation.
Non-diploma engineers
Are being given the scale.
also should be given. Because they are also from the engineering subordinate cadres. We are also from the engineering subordinate cadre. So we also should be given. So that particular thing.
Now the next page, please come.
Yes.
This is 21st August 2000. Huh? 2000? No, page, তার আগেরটা। This circular which you are placing, this is 21st August 2012.
No, 8.
Very cool.
2008. See, the date in the seal may be seen. 2008.
Wait, now kindly come to the next page. What is that?
It has been done.
No, I'm directed to forward received under secretary in conveying approval decision to grant upgrade to non-diploma junior engineers.
Yes. Done by the administration.
So we are non-diploma chargemen, which is equivalent to junior engineer, and they belong to the same cadre.
Same.
Where from we will get that they are belong to the same cadre?
Under judgment of this honorable court.
That is 53.4 clause which you showed.
Engineering subordinate cadre includes charge. That is undisputed thing. They are also admitting this fact. Even the tribunal also is accepting that. What the tribunal is saying, the government of India has taken a decision only in respect of junior engineer and non-diploma holder, so that particular order cannot be applied here. I am saying.
Where is that rejection of the government? That is 17th May 2019 order, which you impugned in the original application.
That is not by government. That is by the authority.
Authorities in fact recommended your case.
When we submitted the representation, we rejected our representation. That is by the authorities only, not by the government of India.
Not by the government.
Government of India has not taken a decision. Not from a judgment. They have not taken a decision.
Then which was the order passed after this? This is 17th of May 2019, page 136,
Yes, that is the order passed by the.
which you impugned in the second time before the tribunal.
Yes,
Yes.
that is by the.
They now here they rely upon that 17 December 2009. Hmm.
Astonishing. This particular thing, 17 December.
According to you, this is not applicable also.
That was a decision which has been set aside by the Honorable High Court. But it has been set aside for the diploma holders. Because those charged were diploma holders. So it was set aside with regard to the diploma holders. Now these people, they are relying again upon the same notification of the government of India. My case was completely different. I was telling that when the government of India has taken a decision with regard to the junior engineer or diploma holder, who are having the same pay scale as that of us. When they were granted, junior engineer diploma holder were granted higher pay scale. Non-diploma holder were granted the same pay scale as what which was given to us. We were in the same pay scale. Now you have taken a decision that non-diploma junior engineer should be given the higher pay scale, like that of the diploma holder. You are making those things equal because people are working in the same post, Your Lordship. They were discharging the same duties. Duties are not different. So practically, the government of India has taken a decision to grant that pay scale to non-diploma holder, considering the fact that both are junior engineers.
Now come to the tribunal order, which is the impugned portion. Triptych order pass করেছে ট্রাইব্যুনাল যেটা দিল পেজ 259
It's not to discuss even Your Lordship properly. And you see, I have not found, only my submission has been recorded and one.
No, they took tribunal took two grounds. Policy decision cannot be challenged. One Supreme Court judgment they have relied. And the second ground is that the first which was made, first order by the WPCT 294, that was pertaining to misquotation of a circular of the government. The tribunal went in this manner that though it was said that not term is there. Diploma in leche is not an essential qualification for the post of chargeman. So the tribunal said that this not had been a typographical error.
The qualification. The qualification of chargeman. Show it something. It was not just a minute, Your Lordship.
Kindly come to page 261, that is the reasoning given.
Yes, yes, I've seen that. Your Lordship. Just 1 minute, Your Lordship. Oh. Just 1 minute, Your Lordship. I just show you.
Yes, sir. Who is for the Union of India? You are appeared.
Not for Union of India, but with regard to the Andaman Nicobar administration, I was appeared before the tribunal.
But who appears for Union of India?
Usually the
Yes, who appears, Ms. Nag? Sir, you are there. Have you been briefed? Huh?
even I
You have not been briefed.
not even I also not received the copy, my lord.
You
That's a difficult. I called them, they said they have it will not been taken day after tomorrow, I take it.
Yes, but who is for Union of India? Do you have the service upon Union of India? Sent. Evidential service is not there.
It's the registry. Because that is the-
But our appointment is the ministry, the concerned ministry will approach the ministry of law. And through ministry of law, we are being appointed. The litigant ministry may not, will refer to back to the law ministry and,
So we engage you.
well, my lord.
Now, have you checked up, Miss Nath, that it was served? You are going to record now.
That is the difficulty, because it has been said, we are not getting postal track. Nowadays, it is very difficult to get postal track. So I will check it out, let it be day after tomorrow, what am I doing? I will send it by mail also.
You give a copy to him also so that from the department.
Both of them. One call.
Yes, ma'am.
Day after tomorrow we
Yes,
take it up. Please come prepared on that issue and
Yes, ma'am.
evidential service দিয়েছে নাকি?
এখানে নেই।
হ্যাঁ এখানে চলে আসো তো। সার্ভিসটা হয়েছে কিনা তো বুঝতে পারছি না, সেন্ট বলছে acknowledgement. Or keep it day after tomorrow, you ensure the service, bring the affidavit of service on that date. If service is not complete,
Eight of 2025.
But I'm seeking 10 days extension to file my rebuttal. I have your order number.
you are for the petition. Let us see the file. You have not yet filed the affidavit.
No, my lord, it's just my lord, last circuit on the Indian days.
Where is Mr. Chakraborty?
I'm apologize on his behalf, my lord. He is in the mainland, my lord, due to some personal difficulty. He will come on Friday, my lord.
So we keep it on Friday. By that time you file the affidavit.
My lord.
I heard Mr. Kumar Lanet, advocate,
Number 4, 2024.
I'm for the appellant. I'm still within time to file paperwork. But this can be taken up tomorrow, by tomorrow morning, I'll serve the copy of paperwork. It's a very short, not
What is the issue?
two votes decree. The defendant preferred first appeal. The order of remand has been passed by the first appellate court, which I've challenged here. My point is very narrow in compass, to also I say, why remand? When the material is available on record, either the appellate court have exercised the juris discretion to allow it or dismiss it. Why remand back? That is the only point which I have raised in this appeal. So far as order of remand is concerned, of the first appellate court.
File your paper, that was the previous direction.
I'm
Come
giving
next.
time, let it come tomorrow, my lordship. By tomorrow, my book is almost ready. Certain.
To file it by, it will appear on next Monday. In the meantime, you complete and serve copy upon the other side. Yes, next Monday.
Number 5, FAT2 of 2025.
Lord, I am for the opponent.
I'll accept notice for the respondent, lordship. Because during the last circuit, direction was for issuance of notice. I find my power to both the matters. Violence.
Lord, in course of today, I will serve my name.
Now, what happened to the SLP?
This is not that matter.
5. This is FA2, FAT2.
Yes.
You read the earlier order.
Yes. With regard to the pecuniary jurisdiction of the first
That is
appellate.
pending,
Mhm.
not yet delivered.
Then why should we hear this? Ultimately, we hold in favor of either of the two. The Supreme Court says that cannot be done, then the entire
But as of,
endeavor gives.
but as of now, the first appeal is maintainable before this court. Today, the appeal is well maintained before this court.
এই যে দেখে এই অর্ডারটা পাস করছে অর্ডার স্টেটমেন্ট নেই
105 may be.
জেরক্স করে না So it ought to have been filed before the district judge.
This was the
Yes.
practice.
Well, the judgment is there at 105.
Judgment was delivered by whom?
This honorable court.
In a different manner.
Division bench.
In a different
Different
case.
manner.
So
Where.
against that, it has gone up to the
Yes, yes,
Supreme Court.
yes,
Issue was whether it will be heard by High Court or by the district judge.
Yes,
no.
This-
Previously, the pecuniary jurisdiction of the district judge is unlimited.
Hmm.
After this judgment, the amount was 1,50,000. Above 1,50,000, we have to approach the honorable high court.
What is the pecuniary jurisdiction here?
more than 1 lakh.
3 lakhs.
3 lakhs.
So High Court has to hear.
Yes.
Yes.
Now then, who preferred the SLP?
In that matter, my lord, page number 105, that party preferred the appeal before the honorable office.
No, what did the High Court say? Page 105.
105.
So against that order, Supreme Court was approached.
Yes.
Now that is still pending. Now what did this court say? Anti-violent opinion is not voluntary. কি order করেছে? Understand direction. So there was an interim order
Yes.
that is expiring when? Oh, there is
After
still
4
such
weeks,
time.
yes.
You are the appearing for all the respondents.
Yes. So, sole respondent. Sole respondent. Being the plaintiff in the suit.
So you have to come, you have to file paper books then.
The entire document I filed, my lord. Everything I filed.
Then what are you wanting?
In accepting notice, also this can be taken up, these two appeals can be taken up.
But when the Supreme Court is in sitting, why should we take it up?
So now, this court is vested with the jurisdiction to decide the first appeal which they have taken up. The appeal is made, admitted by this court. So long the order is operating in the field of this court, which is now challenged before the Supreme Court, this appeal can be taken up. My point of argument is this.
No stay order from.
No, nothing. The appeal is well maintained. So all the appeal was admitted. I am on the point, it can be taken up. It can be taken up.
When is the date fixed in that matter? Can you inquire and tell us that Supreme Court ordered?
I'll come back tomorrow, my lord. I, now-
Have you served copies of all applications upon him?
In course of today, I will serve. Was told, my lord, it was 15th April. SMP.
Yes, after the 8th of October, 2 days, Supreme Court delivered an order. Lost labor right.
So I could have understand that there is an order of stay by the apex court.
No, Mr. Jaipal, I understand, but the thing is, it is a futile exercise. Today we will return a finding, then Supreme Court will say the appeal itself was not maintainable. What happens to your finding? We will be going into the merits of the matter. And that in fact was submitted before the coordinate bench. Oh,
Still pending on this.
Are you sure it is on 15th April?
I'll check it up and come back tomorrow, my lord.
No, if that is pending 15th April, that takes us beyond the circuit. So your interim order is also for a period of 4 weeks. So we keep it on Monday, you come and tell us the date. If it has been disposed of, very good. In the meantime, you complete service upon him. Next Monday.
The second one, my lord. I
Five,
filed
same,
two
same,
appeals.
same.
Same. And formal admission is required, my lord. My counterclaim was dismissed.
All right, dude, both of them will be on Monday. Come and tell us. Yeah, that also you are appearing.
I'm accepting notice.
You exchange the, you
Yes, yes,
give
yes.
the copies and come back on that.
Is there any delay?
No.
Item number 8. 18 of 2025. Item number 8.
Yes.
But for the appellant, but here also there was a direction to file the affidavit and I think paper book also, some papers are not there in the appeal.
You have not filed the
No,
paper.
they have filed an application, we have to give opposition to that application under 17B. They have.
Opposition you have filed.
No, my lord, opposition we could not be able to, since it was short period of time, but could not be able to.
So again, we cannot take it up. Mr. Dwivedi, learned advocate appearing for the appellant, prays for extension of time to file the affidavit in opposition to the application under section 17B.
17B of industrial district.
You are for the appellant.
Appellant.
2023 of 2025.
Which stand for the respondent number one.
Yes. Matt, what is the can?
इसका वो नहीं है, वो नहीं करता है.
Service is complete.
I'm for respondent number one.
Sole respondent.
No, there are other respondents.
I'm actually preparing for point number 8 and 9. Official.
Here for Bhajan Lal. Here for Bhajan Lal.
And I have the information, Your Lordship, that the order which has been passed for the implementation of which I have come before this honorable court,
Hmm.
the single bench, that has been
No,
implemented.
it's going on.
It's implemented, already.
Eviction work is still going on. It
No.
started, it's going on.
It can be
It's going on.
ascertained by the authority.
It's going
It is completed.
Not we are having love with the private respondent.
It's not that.
That's why, short, please.
They have occupied a pathway.
Those things are large, those things are large.
They have to be located somewhere.
So what has happened, Lord?
তো কাছে অর্ডারটা আছে You're coming up against order of 21st March.
Yes.
Who is for the administration? Who is for the administration?
And 8 and 9. Respondent.
Yes, please.
So what has happened, Lord? The property of the present applicant and the property of the private is in same relation,
Within
same revenue relations, same relation,
respondent number one.
private response.
All the
I'm
private
preparing
respondents.
for one.
He is only, have your services complete, Mr. Jayapal?
Just 1 minute, Your Lordship. Big petition.
2, 3, 4, 5, 6, 7. 2 to 7 service is complete. একটু দেখবে Oh, it has not yet come. Everyday service কেন এখানে থাকবে
But I can take instructions, Your Lordship, because I have appeared for the petitioners, all petitioners before the learned single bench.
Hmm.
I can take instructions from others.
Then you can appear,
Only in respect of one, but so far as others are concerned, I can.
so we keep it tomorrow.
Fine.
You come with that instruction.
Yes.
And you are administration.
Yes, ma'am.
So you will necessary, to you will necessary instruction. What happened? An eviction order was passed against you.
Yes, an order was passed without giving a notice to you. I show those orders. There are 4 or 5 eviction orders.
Acha, very good. Then what happened?
Not the a writ was filed.
Eviction order was passed against you.
No, it was not against me. It was against the writ petitioner. That's a very salient feature. But my name do not figure in any of the eviction order. Very cleverly, a writ was.
You are anonymous. You are anonymous.
This is going on
But
record.
Jaipal is not anonymous.
It's going on record. What I'm arguing is based on record. No one will find not should the eviction order is telling my this.
Acha, you say the eviction order was against them.
Against the private respondent.
So if it is implemented, how you are worried?
My property that has been carved out. The excavation was is on my property. That was my specific stand before the writ court.
So no, you were not in possession of the same in any manner whatsoever.
My
Maybe you are alleging to be the owner of it.
I show that papers. The property over which the eviction drive has started now, pursuant to the order of the single judge, is over my property. They are excavating my property.
So what about the suit? You challenge that, who challenged the eviction order?
When the writ was filed, I've come to know that this before the writ.
Under the garb of that, they are taking away your property.
Challenge was thrown to the eviction order, one of the order which carries the land in question. It comprises of that land in question. The civil court in session of the civil suit stayed the operation of the eviction order against which they preferred an appeal, which is pending before today's district judge. Not this is one part. They sought for implementation,
No, suit was filed for declaration
declaration,
that they are unauthorized occupiers.
and for seeking a declaration that I am the lawful owner of the land in question.
But the eviction was not under challenge there.
It was challenged. The civil court, while granting
That
injunction.
is the finding of the court.
I will show the papers now. You can show through the papers.
Very good. You are saying that that suit inextricably bounds both the points. One is the eviction as well as
Everything else taken care of by civil court.
tomorrow. Then please get the that first, it is pending before the district judge, he says, you,
That is different. The learned senior judge, your lordship,
all right.
that both the
Now,
people.
madam, you take instruction as to whether it is over or not and come back tomorrow. If it has been implemented, question of interference subject to what he says has to be considered. Yes, next.
Your lordship, this has to go to the next circuit, your lordship, because the order which has been passed by the single bench, your lordship, your lordship passed the order in the single bench. And this is appeal.
Oh,
Actually, what happened, your lordship passed the order. Thereafter, I preferred the appeal. The order was passed in my favor. The authorities went to the Honorable Supreme Court. Honorable Supreme Court remanded the matter. It is on remand.
what order, what wrong did I commit?
Dismissed my writ petition.
So I committed wrong against you. You are for the petitioners.
Lordship can't commit any wrong.
Really? You will get the test in a different manner. Okay, appeal court, then Supreme Court. Where is the Supreme Court order? It is there.
No, it will not be there. I have alag se diya. Alag se diya. Exactly.
আছে কি বল? Send back on remand.
Yes, yes.
So then it will be heard by the single bench again.
No, division bench. Division bench order was set aside. Remanded to the division.
Oh, I see. Miss Nagel, and the advocate appearing for the petitioners, apprises us that against an order passed in a writ petition being WP number 145 of 2020 on 8th April 2021, the respondents went up in appeal. Being that appeal number is there, it is went up in appeal. And what was the order of the appeal court? Did you state that in your, do we get that anywhere? ডিভিশন বেঞ্চের অর্ডারটা কোথায় গো? এ তো সৌমেনের কাছে। সৌমেন কি বলেছে? ও stop. The order passed in the said appeal was also challenged in a special leave petition and the Honorable Supreme Court by an order dated কত তারিখের order বলো?
16 years.
Order dated 16th August 2022. Set aside the order of the Honorable Division Bench of High Court and remitted the matter to the High Court to decide the matter afresh, examining the scheme notified on 25th October 27. Who is there? Mr. Kumar? Huh? You are for the appellant, first appeal. You are entering appearance on behalf of all the rest. Oh, matrimonial reason. The paperwork has to be filed. Paperwork is ready. First of all, really good. What, divorce granted or not? You are the husband.
Husband filed a petition for divorce that was granted by the family. Appeal.
That was husband filed a petition for divorce that was
Allowed.
allowed. So the wife challenged. Wife has come up before us. What, cruelty?
Cruelty and desertion. Desertion was turned down. But cruelty was.
Yeah, it's been already.
Cruelty was allowed.
Supplementary paperwork was direct.
Thanks for the state lordship. Appeal against acquittal. There are two appeals, my lord, one by the unit and one by the defector corporation. Against an order of acquittal.
No, below 7 years.
No, lordship 376 items he was there. I need to come to division by. But in item number 14, for the victim, Mr. Kabir is appearing. It's not in station. I'm praying for taking it on Monday, madam. Thank you, coming back on Friday.
This is the appeal which has come up before
My
us.
lord, it's an judgment of acquittal, my lord, the state has also prepared an appeal.
You have also.
No, I'm for the victim.
What was the charge?
37 promise to marriage.
Next Monday. Both of them.
Apply.
Monday, you are sure you will can start arguing.
Lordship, Monday.
Then you start today. What is the problem?
Actually, another appeal preferred by Kabir is out of state.
Not a very big matter, my lord.
Monday, I will.
Monday, we don't know. Again, it will be in the list where it will be
On
placed.
Monday, I will.
Yes, next.
Item number 15, 59 and 24.
তুই 3 দিনের মতো সময় নিতে শেষ করে পড়ি সম্ভব
Here, my lord, earlier the court has directed us to file, to submit 10,000 in order to allow our condonation application. We have submitted the amount before the registry.
এই মনোজ তুমি একটু ওই যেগুলোকে কালকে ফিক্স করা ওইগুলোকে উপরের দিকে দিও বুঝেছো তো আর যেগুলো মানডে হচ্ছে ওগুলো আমাকে দেখিয়ে লিস্ট করবে ইয়েস হোয়াট ইজ দিস
We
আইটেম
have submitted the
ডিলে কন্ডোনেশন
delay condonation. Our delay has been condoned subject to, my lord, submission of 10,000 before the registry district.
ইউ হ্যাভ ডান সো
We have done so, my lord. Here is the receipt, my lord. And now thereafter, we can file our paper book and do the final hearing at once.
ইজ দেয়ার এনি আদার কানেক্টেড অ্যাপ্লিকেশন
Stay application is there, my lord, but that can be heard together along at the final stage.
What was the matter
The
about?
the matter is my challenge to the section. Section 37. Seven application. It's an appeal.
Appealed by Union of India.
Union of India. We lost before the state. That's interesting.
There has to be filing of paper books.
What to record has to be called for,
Hmm.
That can also.
and the paper book will be prepared. By the applicant.
And what about your stay application?
The stay is of mine, my lord. It can be heard together at the final stage.
No, what was the, show us the award now, show us. Additional district judge considered the award,
Yes.
section 34. Now, section 34 petition was dismissed. Award was upheld. Award was, what was directed, what was awarded? What was awarded?
The state petition. When you come to the state petition, after the petition, the award is there.
Conclusion that was up to 9.
তো কেন বলছে অ্যাপিলের সাথে সুনামূলক স্টে অ্যাপ্লিকেশন সেই চলে যাবে বুঝতে পারছি
So there is no application clear for state.
See the state petition.
Can do actually.
This is their application.
Yes. So you are not insisting for stay. We'll dispose of the same, asking you to file the paperwork.
At the time of final hearing, it can be taken up to.
No.
Because my lord, if you lordship will see the order, the previous order is specifically say that I have to submit that amount before Learned district, registrar district judge. And my lord, on the submission of that amount, if I fail to submit that amount, they can execute the amount. So my lord, I have right now submitted the amount. But technically, my lord, they cannot with this. With this is our understanding.
Why? They can always execute.
My lord.
They
Or
can,
my lord can fix this to my, Mr. Rakesh Kumar is there in this matter. my lord.
No.
He just asked me to pray this before your lordship.
so you want to use any opposition to the stay application?
Number submission is. Should they deposit the amount in terms of the Supreme Court judgment before the High Court. Then I don't mind if there is a stay.
No, they are not wanting so. They are saying it will be determined at the time of final hearing.
If any stay is granted, 100% deputy has to be made, for the Supreme Court judge.
Right.
That's
So for that you want to use any opposition or not, bring them. Huh?
I need, my client is not in future. I need, time.
time to be
Records reveal that by an earlier order dated, 17 March 2025, the application for condonation of delay was allowed subject to payment of cost of rupees 10,000 to be paid to the State Legal Services Authority, Port Blair. Stop. Mr. Dwivedi, learned advocate appearing for the petitioner, submits that pursuant to the said order, cost has already been complying with the said order, cost has already been paid. Let the memo dated 21st March 2025 has already been paid, as would be explicit from the memo dated 21st March 25 issued by the member secretary, Andaman and Nicobar State Legal Services Authority. Let a copy of the said memo, as produced, be kept on record. Stop. In connection with the next part, in connection with the present appeal, an application for stay being Can 2 of 2025 has also been filed. Stop. Mr. Das, learned advocate appearing for the respondent, sole respondent, prays for leave to file an affidavit in opposition to the said stay application. Stop.
So, here, my lord, I am praying for 10 days time to file my
আর
lord,
সময় পেয়ে যাও খালি
10 days time my lord, to file a credit.
all time matters circular. What was the direction?
My direction is my the some calculations we have to my lord, submit before this honorable board regarding my lord, the reservation quota and all.
Actually, after the selection, they changed the number of vacancies for general and for OBC. They have changed the
After-
content
after
the
the-
selection was over.
Afterward,
After it was over, they changed the number. Initially, it was
you are the selected persons.
selected general category candidates.
So then what happened?
Then don't
You are not
in the zone of consideration, we cannot get the appointment because they have increased, they have shifted the vacancy from general category to OBC.
How the rule can be changed during
No,
the,
because my there
after
was some
game is over.
discrepancy error in that vacancy, my lord, the number of posts and all. So depended due to the directions of the Union of India previous direction and Honorable Supreme Court in various cases, my lord, we have to my lord, change the number after my lord, publication of the vacancies.
I had 2 points, Your Lordship. First of all, the calculation was incorrect. Second point is that, Your Lordship, that they have increased the reservation more than 50% while doing so.
We are denying
Which is
that
not
we have
permissible.
not there. They are saying that it should be in category wise. Reservation should be category wise. We are saying it should be in whole, entire, my lord.
So now all the vacancies have been filled up.
No,
No.
13 vacancies are kept.
There is an interim order, my lord, 13 vacancies.
13 vacancies are kept.
There were 13 petitioners.
13 petitions.
That interim order is still disposal.
Your Lordship.
Sir, you are not interested to have the matter heard out. See,
No, my lord.
there has been about 20 adjournments in this matter. See, matter is pending. 1st February 24 was the first dose. If you go on taking this,
At only 10 days time I require, because this matter pertains to Digley.
we will share and I will share an experience with you. When I was sitting in the principal bench, matter came up that the date was fixed by the tribunal after 9 months. So he came up before us without any preponement application and said, my lord, this matter will never be finished. So I said, why? "No, my lord, this is a contempt application. When it first day it appeared, Mr. X was there, I implemented him. When the matter came over 9 months, that X has retired, now Y has come. So court again gave me liberty to implement Y. Now again the next date came, Y has also retired. And you will be surprised to know what was the order that you consider and dispose of for that contempt. How people are harassed. Sir, if you don't take any steps to that effect, unfortunately, you see the order sheets becomes more than the volume of the petition. You are for whom
The
the
selected candidate.
Private respondent.
3 days time is sufficient for, 2 or 3 days time is sufficient for it.
Well, we have to make calculations and all, why this.
sir to do, sir, your officer has to do.
My lord.
We are not asking you to do.
But that is a tricky part for the officer.
2nd April.
Or else your lordship can keep it on any day in the next week, my lord, we can do it.
সোমবার দিনকে রাখো
Kindly keep it on Friday, my lord. Kindly keep it on Friday. Like,
Friday they will not
I-
file.
Having some personal difficulty, my lord, I will not be there in the next week.
Let it be on Friday, let us take a chance. Shivaji.
What chance, madam? We will not be able to hear.
It is not a matter relating to finding of affidavit. It's a matter only relating to calculation. That they can do it, your lordship. There is no difficulty in making a calculation.
No, no, he has been asked to একটু দাও তো একটু দিলে যে
You have been asked to file the calculation.
you have been asked to file an affidavit incorporating that distribution
My lord.
with an advance copy to the petition.
Fine. That might within Friday might be very much difficult for us to.
So after Friday, he will not be here. He will say for, let us see on Friday.
Fine.
I'm
If you can
indicating
come.
in advance,
I'll
my-
come.
Hmm?
Indicating in advance so that the matter is in the next week.
আর কি ইন্ডিকেট করবে সব কোনো Yes, next.
One person is one of both.
কোথায়?
Item number 17.
Your lordship, day after tomorrow, I am bringing it. Day after tomorrow.
Why your affidavits and everything complete?
Everything completed, your lordship, paper book has to be filed by day after tomorrow, it will be ready. I'll give a copy also to the
Day after tomorrow.
Item number 18, event 76 of 2024 with item number 19, event 1 of 2025.
I am appearing for respond number 2.
There are two matters.
Paper book direction was given. Paper book is not given. Mr. Rakesh is in this matter.
Paper book is not filed, last sticky here.
লিস্টে কোনো মানুষ নেই। IPC also তাতে কালকে ম্যাটার থাকবেই না ডিভিশন বেঞ্চে।
Only one matter is increased, paper book is ready.
চেক করুন।
Next one, যেটা হলো ready আছে। Matrimonial dispute. ওটা ভালো করে শুনে
ম্যাট শুটটা কি প্রথম?
matrimonial.
Yes, what is this matter? Mandamus appeals from honor. You have not filed the paper books.
No, Mr. Rakesh.
What was the matter about?
A delegated employee was working at the Adama Public Work Department. Subsequently, my lord, he was sent to the electricity department. Now, my lord, while he was working under the electricity department, time to time extension was given to them. My lord, this extension by the passage of time, it was done through Kotur. that daily rated employees portal maintained by the Andaman Nicobar administration. Due to the mistake on the part of some officer, my lord, his name was not uploaded in the same. As such, he was not allowed to discharge his duties
Since when?
for a particular period, my lord. Then, my lord, the matter went before the conciliation. We filed a conciliation before the conciliation officer saying that no fault on his part, my lord, this was done. They candidly admitted they are wrong, that due to the wrong on the part of the officer, this was done. Tribunal, the conciliation officer directed them to immediately allow him to discharge his duties by incorporating his name in the said portal. Despite of an order, they did not comply with. We took out a writ petition before this honorable court saying that due to no fault on my part, I have been deprived. This is the only source of relief. The writ court directed them to immediately upload the name and allow him to discharge the duties, and directed them to pay 40% of wages for the said period because he was not at fault. Now, my lord, that order was, after that order, my lord, they have complied it, they have uploaded it, and they allow him to discharge the duties. Now, before compliance of that order, they have challenged it on twofold, my lord. First, on the fold that they cannot be, unless.
So this appeal has become infructuous.
They say that now, my lord, they are arguing that the 40% payment, which the court directed, that cannot be. And I have filed a counter claim saying that, counter appeal, saying that instead of 40%, I am entitled for 100%.
Where is that?
Both are tagged
Act
together.
one, my lord.
Both are tagged together. I say that when it is an admitted fact that due to their fault, I have been not allowed to discharge the duties. Why? It is not a simple case where a person has been dismissed from service and thereafter reinstatement, he is not entitled for back wages. It is not that. Due to your fault, you did not able to upload, and this fact is admitted in document before the.
No, if after compliance they have preferred the appeal.
Not after compliance, my lord. Before compliance, they.
No, thereafter they
Comply.
comply with the order.
Comply.
So what remains in the
Yeah,
order?
but there is a judgment of Supreme Court that with the fear of my lord contempt, my lord, we have complied the order, my lord.
Huh?
With the fear of my lord contempt, we have complied the order, but we still have the chance
No,
to not in appeal because 40%, the person is not worked for that.
They are.
How many days after, before implementation appeal was filed?
My lord.
Contempt application came up.
No, contempt application was not filed.
So
because
they
we
was
have
not
filed-
a threat of contempt.
No, we didn't file any contempt application.
Then they, good sense prevailed upon them, they complied.
They complied, my lord. Now they are arguing that 40% payment.
We understand
Yes,
that.
yes.
When was the appeal filed?
Appeal filed prior to compliance of the order.
And thereafter they have complied.
Complied.
So what remains in the appeal?
No, but my lord, we are asking for that 40% because my lord, he have not worked for that period of time.
You ought to have asked for that before complying with the order.
But my lord, we have
Where
complied.
is the order of this single judge?
If it won't comply, my lord, there will be a contempt. Someone will be my lord, punished. So that's why my lord, we have to comply. My lord.
So we will remove that iota of punishment. You comply to appeal for 40%.
But my lord, we are on that 40%. My
Show
lord.
us that report. Show us that order. appeal টা fail করে যে একটা ফর্মুলা আছে ওরে কমপ্লাই করে কমপ্লাই করে দিয়ে এখন বলছি 40% ওটা ভুল আছে
Page number 19, my lord. Then he order.
So 40% was paid to you?
No, 40% was not.
That was not.
Only he was reinstated. His name was uploaded in the portal, but that 40% was not yet to be paid, my lord.
And you are claiming 100%.
100%. I am claiming 100%.
Counter claim is there.
Yes.
What is the fate of that counter claim?
My lord, it is there. Both the appeal are there, my lord. For my lords.
Now what about the conciliation proceedings?
Conciliation has become practically infructuous because conciliation officer said you comply, you give it to him. You reinstate him, upload him. They have not done. Thereafter, we filed this writ.
So you came for implementation of the order of the conciliation?
Yes, we say, my lord, first.
No, where is that order in the conciliation proceedings?
My lord. My lord, may kindly see 28th of June, page 50.
Writ petition was disposed of on the basis of a report.
My lord, the report submitted by the authorities.
That report you have did not give copy?
No, that was.
Mr. Kumar, you are also not ready.
Well,
You have not also checked.
No, they have not given all the
If
documents.
the
my lord.
matter is to be adjourned like this, you are also not taking any care. You don't want an order from the
No,
court.
no, my lord. My lord.
So that is, you are not ready.
They have not filed the paper book, my lord.
Both the petitioner and none are ready. And we are the only ready
No,
person
ma'am.
sitting here and waiting for you to say something so that we can pass some order. Very unfortunate. The litigant goes on suffering, 40% still pending.
They have not infused.
Why haven't you filed the paper books? By 15th March, the direction,
Direction of the
it was by 15th March.
15th March, my lord.
Hmm.
The certified copy, I guess, not.
That is required. Oh, you don't get it in the server.
No, that is requirement because in that order is recorded that we have to file certified copy along with the paper book. So that is,
Where is the requirement for certified copy? That order is already there.
yes.
The order which you have assailed, that order you have annexed server copy.
Yes, sir.
Now you,
We have,
so maybe you preferred the appeal without the certified copy.
my lord, we have paper book. And my lord,
Paper.
we see, paras.
Things that you people are not serious. Let it lie. The actual explanation is not serious. When can you file the paper?
Within a week, my lord.
Monday.
Great.
The point which was put up. Huh? Who's put it? Yeah, nahi.
Item number 20. WPA P1 of 2025.
Sir, in this matter, so I am the petitioner in person in this PIL, public interest litigation. Actually, no affidavit of opposition has been submitted by the respondent.
Let us see the file. Yes, you have filed your opposition.
First extension I have settled. Only 2 weeks time. It's my fault. I could not be able to draw the affidavit.
Sir, this is a serious issue where the unfit buses without any insurance and fitness is running on the road, and due to which 2 to 3 lives already been lost. That due to the road accident.
They have
They are
taken.
running, the administration is running state transport buses without any fitness certificate, without any insurance. People died already. So what I request is to pass an interim order, at least to preventing not to allow unfit buses to run on the roads. That is my request. Because if any mishap happen, this court will be equally responsible as the administration. Because the court,
So
even
why you say so much of things before the earlier court when it was passed? So much things, so many things, court will be responsible. Where was your argument when it appeared first? It is very easy to sit in the chamber and make observations about the court. Why didn't you raise that objection?
Sir, I raised the objection, but no interim order has been passed. This is a serious issue because already accident happened, life has been lost.
Your arguments which you are advancing. Before making the court responsible, you rectify yourself.
Sir, I already requested the court.
Given to you of independence that you can sit in your chamber and make whatever utterances are required before the appeal court. Court is responsible. What is court responsible? Why didn't you perform an appeal against this order? You yourself said that I will give them time to file opposition. Monday, if you don't file opposition, we pass our order. No further explanation.
Thank you, sir. Thank you.
The interim order, this is not required that the unfit vehicle should run.
Vehicles only after obtaining fitness certificate.
If we pass an interim order to that effect that no unfit vehicle without fit certificate would run, then there will be no problem. This is the law.
No, there is no problem, my lord.
Then what is the
Of
possibility
that order.
this interim order?
We don't even run vehicles which are unfit, my lord. We
If
run all
we are there is no problem.
my lord.
Where is the application he has filed? Yes, please, what is your matter? Yes, tell us.
Even, my lord, with that order, my entire application can be disposed of.
What is his allegation? Yes, tell us, tell us.
Sir, in this matter, what happened is the unfit bus. Sir, buses, state transport buses without any fitness certificate.
Be able to hear you.
Sir, I am also not able to hear properly, sir.
But I am saying.
When you come over, where you are?
Sir, I am at Delhi now, sir. I am at Delhi now.
Huh?
I am at Delhi now, sir.
You are in Delhi.
Yes, sir.
What interim order you are asking?
Sir, I am asking that no unfit buses without any fitness certificate should be allowed to run on the roads. Public transport buses, sir.
Saying their allegation is they are not running any unfit vehicle.
Sir, due to running of unfit buses, accident occurred, 2-3 lives already lost. The youngest one is 14-year-old, the youngest boy who died.
Yes, please show us that, show us that. Show us.
Sir, there are media reports. I have arranged all the documents in the petition.
What interim order do you want from us?
Sir, just to not to allow unfit buses without fitness certificate to run on the roads.
The law. That is for that any order is not required. If they still run unfit, in your appropriation, what is the relief you are wanting from this court? Not to ply any unfit vehicle. That is your want.
Yes, sir. Yes, sir. Sir,
Evidence that they are using unfit vehicles and earning money. Show us some material.
Sir, could you fix that matter tomorrow? Because I am having fever now. Today I am having fever, sir. So my health is not good tomorrow, sir. Kindly fix it tomorrow. I'll argue tomorrow this matter.
We are keeping it on Friday. If you file any opposition, you serve a copy upon him. And if you want to use a reply, you immediately use a reply.
Sure, sir. I am having fever, sir. So my health is not good, sir.
Friday.
Convention of
Any mentioning not in the list?
I would like to mention one matter, my lord, this is a fresh matter. Without service, I want to, there is an extreme urgency. Here, my lord, after the division bench order, the estate officer has passed an order without
Be
jurisdiction.
there tomorrow, file.
My lord, they have given the notice on 26, they have passed the order, on 29, they have come and they have partly demolished some portion. 29th on Saturday. That's why this is an urgent, my lord.
No, urgent, but we can, it has to be, I can direct it to appear tomorrow. What is your prayer?
My lord, dispensation I have paid for, my lord. For service.
29th was the notice.
26th was the notice.
Oh,
Received it.
Who is for
I
the
have
administration?
Babita Das.
Do you appear? Give a copy to her, it will appear tomorrow. Yeah, man. Take instruction and come back tomorrow. Did you get the certified copy? You're filing with the certified copy or without the certified?
Not certificate
Oh,
copy.
sorry, it is the fresh writ petition.
Fresh writ petition.
Then you file it in the department, give a number to a court officer, it will be there tomorrow in the list.
My lord.
Madam, you take instruction in the meantime, give a copy to her. You are for the administration, no? ওটা তাহলে দিয়ে
My lord, I will satisfy.
we will hear that too.
I will satisfy, my lord.
Look, there are 7 identical matters.
Huh?
There are 7 identical matters. Maybe listed tomorrow.
Are you mentioning about notice?
No, I'm mentioning this
Give a
matter.
notice and mention to.
No, I had already informed the other side, Mr. Shiva Balan. I'll give a notice to him in return today. I had already informed the other side.
What is this matter about?
But the property was consumed without any authority of law that have been questioned in this.
Where from? You are,
They both are saying in the same book.
who is your other side?
Mr. Shiva, he has put in notice to us.
No, there is a direction to file opposition.
Long ago. it had lapsed.
No, we have extension was given.
No. The default of,
All right, we
I will
keep
say
it.
extension of time.
this way this can't be done. I mentioning this can't be done.
No, when it was made returnable, Mr. Jones,
2024, time lapsed long ago, but 4 months lapsed, they did not sought for extension. I want the matter to be taken up for final disposal. They have not filed the opposition. I have challenged the order of lordship basically on the ground of violation of principle of natural justice. Even then, they sought time for filing opposition, this was granted.
Matter pertain to Mayabandar, my lord, I will take some
no,
instruction.
that was maybe Mayamandal, but it was direction was 6 months earlier. You take instead day after tomorrow.
My lord, I'm ready.
If you want to put in anything on record, if you cannot affirm the opposition also, give us the copy, we will consider and dispose of. Yes,
Deeply obliged, Lord.
ওটাকে তাহলে day after tomorrow দিয়ে দিই।
Item number on. WPA 178 of 2025. Offer the petition, my lord.
Yes.
Service has not been effective in Friday. To pay this matter may be taken up on next Tuesday.
Then why did you file it? If you after filing do not file, do not complete service, the learned advocate appearing for the petitioner submits that
Item number 2, WPN 94 of 2025.
For the petitioner.
And for the officer response.
Yes.
Private respondent.
Yes, Mr. Khan.
Lordship, Tahsildar, the private respondent approach to the Tahsildar against the.
I've served the private.
Yes. Earlier she appeared also.
Yasmin Begum.
Yes.
Is she here? Hmm. No, what is it? Let us see what is the matter. Yes, Mr. Khan.
Lordship, private respondent approach to the Tahsildar
Hmm.
against one John Bose. And asked for an stay on the ground that she is making construction upon her land. Tahsildar, page 14, your lordship, may be seen. The proceeding was initiated by the Tahsildar against the John on the basis of a complaint filed by the private respondent hearing. Then Tahsildar pass an stay order also, page 50, against that person.
He is not a party here.
He is not a party here, John Bose, because he earlier filed a writ petition before this court challenging the proceeding before the Tahsildar, and subsequently this private respondent approached to the appellate authority. That order of Tahsildar and appellate authority has been set aside by this honorable court in page
No,
24.
after the stay order was passed,
Yes.
first revenue appeal was preferred challenging that order.
No order was challenged, but approach to the sub-divisional officer. Page 24 may be seen, your lordship. This court set aside those orders.
Those orders means which orders?
Order of the Tahsildar which he passed on the basis of the order passed by the appellate authority.
Three to 25 and 5 to 25.
Though the private respondent has not made any complaint against one.
After this appeal order was passed,
Yes.
page 18 is what? 5th February 25 is what order?
This is the order passed by the Tahsildar based upon the order passed by the appellate authority. Appellate authority order is, your lordship. That will start from page 16.
Very good. Now, what is your grievance now?
My grievance is after this order passed by the writ court in the another proceeding. Tahsildar calling me, you participate in the proceeding. When there is no complaint against me by the private respondent.
You were also a party in that first revenue appeal.
First revenue appeal, because that order is.
So that order is set aside. So what remains in this petition?
Tahsildar is calling me, issuing notice, come and participate
Show us one
in the
notice.
proceeding.
Where is notice?
Lordship, earlier occasion I filed that notice for this court also. That is on record. 6 March. This is a dispute between private respondent and one Mr. John. But Tahsildar is calling this.
No, you were also a part of the land. You were also the recorded person.
No, I am no concern with the party of the earlier writ petition.
Earlier writ petition means that John, the complaint page 16 was
against John.
As per Gomathi, they have filed a complaint recovery of as house site at Kalia, which has been illegally occupied by 2 of the neighboring tenants, namely Kulanthamalla and R. John.
That appeal was filed before the appellate authority.
Very good.
Initial proceeding was filed page 14 before the Tahsildar. In this proceeding, he is calling me. When appellate authority order was set aside already, my chapter is closed not to appear.
No, RC, where is that? This order at page 18 was passed in which proceeding?
Page 18 passed order on the basis of page 15.
No. This RC number differs. Page 18, RC number is 1961.
Yes, that is page 14, Your Lordship.
Oh, I see.
Page
So
14.
what order you are seeking from?
I am seeking that when the order of appellate authority has been set aside by this court, and when the proceeding was initiated by the private respondent against the one John. So why Tahsildar unnecessarily calling upon me?
Now, in the appeal, you were also a party.
The appeal order has been set aside.
That is
Nothing
separate.
remains. But Tahsildar, as I shown the notice, calling me to participate, and he.
So the order which was set aside of the Tahsildar was 3rd of February order.
Yes, Your Lordship.
No, the Tahsildar's order was 5th of
5th of
February.
February.
What was ultimately a directive to vacate? Yes, Mr. Shivavan. How that proceeding has culminated in an order on 5th?
This also, in this page number 18 also, RC number is same, 1961.
Yes.
And here is also John and petitioner is also their party.
That is a
No,
authority order.
in RC 1961, kindly come to page 14.
Yes,
John and Gomathi are party.
all, page 15 also 1961, page 18 also 1961, all are same RC number.
Then
No, page 14
Yes.
is 1961.
Yes,
Wherein you restrained John from making construction. Stay order was there.
yes,
Now thereafter he preferred an appeal.
yes.
How did he go up in appeal under section 28?
That is was ruled by this court that appeal was also not maintainable before the appellate authority. The matter is pending. So considering those things, order of Tahsildar and
Has
passed
been-
by the appellate authority set aside.
Very good. Then how you are agreed now?
My submission, Your Lordship, page 14, complaint made by the Gomati against one John. I am nowhere in the picture. I came on the picture on the basis of order passed by the appellate authority. That order has already been set aside by this court and no appeal preferred against that order. So why?
You are not a party to the proceeding of RC number 1961.
196. I am not party to that.
No, in India, every proceeding, they are the parties.
First order is speech.
Show us that.
Page number 16. They are the
17th of March 2025, what happened?
They asked for demarcation. Came for demarcation. I objected there.
Mr. Khan, kindly come to page 16. Read
Yes,
the brief facts of the case. Read the first paragraph.
Lordship, this order has been set aside by this court.
We will come to that.
Yes. Brief facts.
Proceeding has not been set aside. The order has been set aside.
No, I will come to you, Lordship, page 24.
Yes, page 20.
Page 24, last para 25. Thus, it is evident that the Gomati approached the concerned sub-divisional officer during pendency of the proceeding 1961 without considering the fact that said.
Where you are reading? Page 20.
Page 25.
Yeah.
7.
Hmm.
Thus, it is evident that Gomati approached the concerned sub-divisional officer during pendency of the proceeding RC number 1961 without considering the fact that the said proceeding was still pending before the Tahsildar. Sub-divisional officer passed an order 3/2/25. Accordingly, since the order dated 3/2/25 was not in accordance with the regulation, it is flawed. An order passed 5/2/2025 passed by the Tahsildar in reliance on the order dated 3/2/25 cannot be sustained. In the light of this, if both the order are set aside, the Tahsildar is directed to dispose of the proceeding after giving an opportunity Srimati Gomati for hearing. She will not be prejudiced. In view of thereof, both the orders passed by the SDO.
So the proceeding has not been set aside.
No, because
Proceeding has not been set
matter
aside.
has been remitted to the Tahsildar.
That is the line. Accordingly, since the order was not in accordance with regulations, it is flawed. And the order 5th February passed by in reliance of 3rd February cannot be sustained. Both the order Tehsildar is directed to dispose of the proceeding, affording Shanti Gomati an opportunity of hearing.
Yes, I am not, we are concerned with
So
that.
you go and tell that.
No.
How you cannot be concerned because same land part you are claiming to be the owner.
No, Your Lordship.
That is paragraph 1 at page 16.
Page 14 may be seen, Your Lordship. Page 14, the initial proceeding.
I don't know. Kindly come to page 16. What is the fact? Gomati said that they have filed a complaint against both these persons before the other requesting for recovery of such and such area classified as house site sitter under which has been illegally occupied by two of the neighboring tenants.
You see, this order has been set aside by this court.
Right, set aside your contention is now the main proceeding is going on
Before the Tehsildar.
Before the Tehsil in which I am not a party.
Yes, because no complaint is made against me.
Complaint what? Complaint what? Mr. Shivawalam, he was a party. It is all along 1961.
I was not party before the Tehsildar.
Where from we will come?
Even Tehsildar, page number 18.
Maybe seen, Your Lordship.
The last one.
Order sheet itself says that Shri Gomti made a complaint against John Bose, not against me. Page 14. An stay order was passed against the John Bose, page 15. I was not party before the Tehsildar.
Go and tell that to the Tehsildar. We will record that. And you are saying that you are not a party to the proceeding.
Yes,
but we will record that. You say that to the Tehsildar, that how can you pass? We don't know the complaint or show us the complaint. It is part of the complaint was involving two persons.
No, Your Lordship, that was not the complaint.
Tehsildar is directed to conclude the proceeding after hearing all the concern.
Yes, all the concerned you will proceed. What is your problem? We will record that.
If complaint is made against me, I will appear before the Tehsildar. If no complaint made by the private respondent against me before the Tehsildar.
That is not being able to be ascertained from this. All throughout the, kindly see the RC 1961 page 18, kindly come, Mr. Khan.
Same RC.
Wherever a stay order was passed against construction carried out by John, the thereafter Gomati against the work done by John. Revenue figure conducted jointly demerit revealed an area of such and such in favor of Gomati is currently under occupation of you who are the recorded tenant of survey such and an area component recorded favorable is found to be under the provision of John. This is the complaint.
But I am showing the first order passed by the Tehsildar, page 14, in which there is no whisper against me.
That does not establish. We will say that both the orders have been set aside.
Yes.
And we will record your contention that there is no complaint against you. If there is no complaint against you, no order will be passed.
Yes.
That will prejudice you because if you don't hear,
Yes.
don't appear, then you would be, we will say that they have granted an opportunity to you.
Yes.
My lord, the order which has been set aside, in those orders, the petitioner is the party.
I am not party.
Order that is number 3rd and 5th.
Yes, in third she is a party.
Yes.
But not in the fifth one.
Yes.
Fifth one is the CVP 1961.
I was not party.
Fifth also there.
There also?
Addressed to the both the John and petitioner. Page number 18.
Decided by this court.
Page number 18, bottom.
The present writ petition has been preferred.
Item number 3. WBA 1.
Mr. Shivamalan, proceeding still continue.
Yes, sir.
अच्छा वो मिस्टर शिवमलन वहाँ एक लाइन ऐड करना है he further submits upon instruction that the proceeding being RC such and such is still
3, my lord, I am seeking extension of time to file opposition.
On 17th March
First
2025, this
exception.
court has passed an order and interim order was also passed.
you're protected.
First extension.
Give for a period of 6 weeks. When will you file?
2 weeks, my lord.
Of 2 weeks we have.
No, my lord, yes, my lord. My lord, this ought to be extended up to 10th of June, my lord. Otherwise, I will be in difficulty.
He forgot.
Yes, my lord, I forget.
No, he forgot. He has so many matters, he forgets some.
No, my lord.
Mr. Shivamalan, learned advocate appearing for the
Respondent 1 to 5.
1 to 5.
WPA 145 of 2025.
Yes, sir.
Madam, for the respondent in this matter.
Now the gift. Who is your other side?
So Rajendra Singh is for the other side.
Rajendra Singh. Since Mr.
And my affidavit direction was there, but I'm prepared in this matter. I can do this matter even without affidavit. But
Have you filed your affidavit?
not today. No, but my affidavits are not prepared.
There is a direction for
Directions 2 weeks, but it was only 5 days gap.
Just a moment. Where is the direction for affidavit?
Last.
No, this is Central Studio and Calcutta.
Central Studio.
Did it squash the order? There is no direction for affidavit.
So I can do the matter. I don't, but since the
You
petitioner,
do it. What is stopping you?
petitioner's advocate is not there, man.
Yes.
So on behalf of Rajendra Singh, sir, he is not present today, so we can take up tomorrow or the after.
Only man, this page number 159 has to be considered the entire matter, nothing else than that. 159 is the order they are challenged in the matter.
Yes. Yes, tell us.
Take up to.
But the matter is that the petitioner has taken some photographs and video at the time of 2019 election. Now his contention, he has not been paid for that. Now, my lord, he has raised some, his concerns over previous writ courts also. Writ court had directed us to consider his representation after hearing. We consider his representation. We have given him chance to appear 2 to 3 times, my lord. We have written that in page number 159 order. That happened after 1 year, 2 year, whatever it might be.
But the time given.
There was a contempt, my lord. After that, we have passed an order. This order has been passed. This order says that we have given.
You have dismissed it on the ground that the acknowledgement has not been
given to
So,
us.
sir, come to the contract. Let us go to the contract.
My lord.
What is clause M?
Clause M, my lord, it's written, page number 160 only, it's written.
You read it, what is?
But my clause M says that full videographs of each event should be done.
So where it is said that acknowledgement has to be obtained?
No, I say in clause N also, my lord.
No, first let us satisfy yourself, you are ready to do the matter. You show us where is that line that the acknowledgement has to be provided by your officer to him.
I must search it, my lord. I will also come.
Your officer is playing tricks.
No, besides it,
Something which is not there in the contract, how can you impose that barrier?
But I will see it.
So you have extracted what from them? Now you are raising 5 to 6 points. That order, that acknowledgement you have to bring, see clause name, where is in clause N that acknowledgement has to be brought. You produce your records, what you have done with the other tenderers.
Now we produce our records.
You suddenly come tomorrow with all the records.
No.
Yes, sir.
It's their duty also not to participate. They fail to participate.
You are the state, sir, who is act in a fair manner.
No.
If there is a clause in the contract, this writ petition we would be dismissed immediately.
No.
But when there is a contractual obligation on your part, you cannot incorporate fresh terms in the contract.
I'll come with the contract. The contract is also not a part of this melody.
Yes, it is so there, page 24.
Page 24.
My lord, as per contract, they have asked us to submit original
That
data within 3
an
hours.
adjournment. Don't think that the court is in your favor. You are wanting questions.
I'm just adding up the information.
You are getting information tomorrow. Come with the Mr. Divedi.
Mother.
Kindly consider 2 things as you are in the matter.
Mother.
You have rejected him on the ground of clause M.
Clause M.
Now, if you see the pages from all the annexures, it will appear that the team leader's signature was there. I don't know who is the team leader. It is their man or your man. If it was your man, then they have receipts to that effect. Tomorrow.
Great.
Tomorrow?
Sure, sir. Tomorrow.
And should come ask your senior that where is the acknowledgement. It is not believable also that you will hand over something, you will not ask for a receipt.
Sure, sir.
It is ascertained from your plan. Yes, next.
Great. But the next matter is similar. Similar.
So we keep it tomorrow?
Yes.
Mr. Divedi?
Yes, mother.
Item number 6.
Yes, 6.
WPF 155 of 125.
Yes, sir.
Item number 6, I am appearing for the writ petitioner, my lord. A direction was given upon the union and the administration.
Well, we seek time to file our affidavit in opposition. The union is not there.
14 days time was given to.
They are seeking for tsunami compensation. This compensation, mother, basically this amounts come from the Union of India, mother.
Period which they completed. Monday completed.
Yes.
The time period itself will over next Monday, mother, to file our affidavit in opposition. They challenge our order. We have rejected their claim.
Time period expires when?
Monday,
Next Monday.
Next Monday.
Coming Monday.
Then how can this be before this?
My lord, it can be, my lord. Let them come with whatsoever document, the original documents. That is why the direction was specifically given to bring the original files. If the original files comes on record, it can be very well displayed. For that reason only, no liberty was also given to file affidavit in reply.
Yes.
Yes.
Direction was given to file evidence.
Yes, ma'am. But
Mr. Shivabalan is there.
they are for union.
You are
Union of-
the administration.
No, for administration,
They are for
we
union
are
of-
for the administration.
No, you are for union only.
Yes.
You are the administration.
Administration.
Acha. You have been also asked to file an
Yes, my lord,
evidence.
regarding the Vivek Rai Committee for Enhanced Compensation. A committee was formed by the Union of India. And certain recommendations were forwarded, which is pending before the ministry for consideration. Even on the last occasion, a letter was.
The petitioner submitted his lands, submerged lands, to the Tehsildar. The DC says that no, that is the wrong thing, Tehsildar cannot admit his surrender. And on that basis, his consideration has been rejected. Now there is the Vivek Rai Committee for Enhanced Compensation in lieu of surrender of the land. The DC says that you, after Vivek Rai Committee has to be admitted, whether it has to be enhanced or not, this entire thing issues will be done.
No, if he has not, if the Tehsildar has done something which was not within his
My
jurisdiction,
lord.
then he should have to be intimated that why I am taking you have admittedly taken the land.
The Tehsildar I will have
So
taken.
if it was a wrong on his part, he ought to have raised that issue. And the after calculation of compensation, how can you say that the issue of enhancement is under consideration, but we will not pay you?
No, but because my lord, he has received compensation, you are certain.
You have received.
No, my lord.
You have
He
received.
the chunk of land. He has surrendered, previously surrendered 3 point some hectares. He has received that amount. Next, thereafter again he surrendered 2 point an odd hectare of land. This is only regard to that 2 point an odd hectare.
No, earlier one was before the Tehsildar.
No, not before the Tehsildar.
That was before.
It was before the deputy commissioner. Or there might be some committee. I have to look into the records, madam. But not to the Tehsildar it was.
Next Tuesday, Rekha.
Yes. August.
Item 7 already fixed. Item number 8.
Yes.
WP 176 of 2025.
For the petitioner. For the petitioner.
And for the respondent.
My lord, here the my lord, on the basis of a scheme, license was issued to the petitioner. My lord.
Pardon?
On the basis of a scheme, under the scheme, a license was issued to the petitioner. My lord. Thereafter, my lord, the premium was never the assessed.
Premium.
Premium was never assessed. Premium has to be assessed by the authority. It was not done, my lord. Thereafter, my lord, I have filed a application before the authority. The demarcation notice was given on 14/10/2019. It's at page 20. Thereafter also, no, after this notice, nothing was doing, in lordship. Thereafter, my lord, I have filed.
No, please tell us,
petition.
this collection of premium, you have given the land to somebody.
No, my lord. After getting the license, my lord, after allotting the license.
License for what?
For land. For land, my lord. It's there, my lord. I'll come to that.
License to occupy your land.
Land.
Acha, very good.
My lord.
But they were not taking premium for that. License fee was not assessed.
Not assessed, my lord.
That
It is-
premium means the license fees, no?
License fees, my lord. My lord, it's in the license itself, it is mentioned, my lord.
Where do we find page 19?
Page 19, my lord, it's last 6, my lord. The license is subject to the payment of premium as may be determined fixed by the administration.
So
This has to be determined by the authority.
this was of 1989 license.
1989 license.
And you are deciding there.
I'm deciding that. It was not determined. So I have filed an application on the basis of that. Kindly see next 20 minutes. Notice was issued by saying that there is some excess area and all these things. Thereafter, after this notice, my lord, nothing was done. I have filed a writ petition, my lord. Next one is the there was a direction, my lord, to assess the premium and tenancy may be created within 6 months. That was the direction, my lord. It was on 24/11/2023.
To assess the premium.
This is the premium. This is the direction, my lord. After this, my lord, there was another direction to surrender the excess area also to me. That was, I've done on, it was on 26th, I've done it, my lord. Surrendering the excess land, I've given the.
No, why did you surrender? Any notice was issued to you?
No, my lord, because the license is for the area of only, my lord, it's the area of 140 square meter.
Where do we find that one?
It's in the license itself, it is mentioned, my lord.
140 square meter, yes.
Yes, but I'm possessing more than 140 square.
So you surrendered
I've given the letter by saying that I'm ready to surrender. I've given the letter. as well
That is
as
a
the-
vacant land, 30 square meter?
Yes, my lord, it's a vacant. I'm ready to surrender it, my lord.
Then what happened?
This also, I've given the reminder also, but till now, no action is taken.
Yes, Mr. Siavalan.
This is the second time I've made.
Disputed question of facts.
My lord,
What disputed questions are? You have to take money, you don't want to take money.
there is a direction, first direction is there, my lord.
So you should have filed a contempt by this
My
time.
lord, my lord,
You did not file any contempt.
no,
There can be what two directions given, we strengthen it.
not like that.
If I again say that consider
Contempt period has
that we
expired. Contempt period has expired, that's why I filed the second thing. That's the thing happened, my lord. I've given the reminder also.
for implementation also one can come.
Yes.
This is in fact she is seeking implementation of the target.
Start on.
Yes.
Good bad indifference sir, ask your busy officer to pass any order.
Yes, my lord. I will.
You will.
I will advise. That is already a direction.
First order is already, direction is there, my lord. It's not consideration, my lord.
Beyond-
Direction order was there. In spite of that, the authority has not done anything.
You file a report before. You finish. Then he will do, otherwise he will not. He will file a report as to
My lord.
whether.
Will file it.
Huh?
Yes.
Mr. Shivavalam, it is you are officer of this court. You should
Right.
tell your client what have you done. You are not obeying court's order. What
It
is
is a old
have
matter.
you got instruction, Mr. Shivavalam, that why he is not doing it? This is a Tehsildar or a deputy commissioner.
Deputy Commissioner.
Or the deputy commissioner is a highest officer.
I shall submit. I will take instruction and I will come back.
You are meeting a party.
Yes. Number two. Respond number two. Or I shall submit report also.
Now, where from we will know, page 26, that your surrender of excess land.
It was submitted on 8/12/2023, my lord. 8/12/2023. I've submitted by saying that I'm ready to surrender my excess land, that is 30 square meter. Which is reflected in the High Court order, my lord.
So this demarcation is done by whom? The deputy commissioner or the Tehsildar?
Tahsildar.
But the acceptance of premium, that has to be, that order has to be passed by the Deputy Commissioner.
Why did the court say to grant tenancy to you? Your license?
No, license is there, my lord. Thereafter, my lord, once the premium is accepted, the ROR and the sketch map, thereafter it will be prepared, my lord. Then the tenancy. Because now only the
So,
license.
Mr. Siavalam, you take instruction and come whether you have passed any order or not.
Yes, my lord.
On the earlier prayer was the prayed for an adjournment. So, Leko hard Miss Sujata, learned advocate appearing for the petitioner.
Mini.
Miss Sujata. Sorry.
Lordship, I am for the.
Yes.
If I am the private respondent,
Lordship, I am appearing for the official respondent. This is an application for seeking electric connection, Your Lordship. Electric connection was there in. Here, Your Lordship, one more thing before I start. Affidavit of service I already have filed, but service upon the respondent number 10 was not completed, Your Lordship.
Yes.
So if.
Yes, what is
Service upon the.
since it is submitted is not well. You took adjournment. Yeah, how many private respondents are there?
I am appearing for respondent number 5 to 9.
There are 11 respondents are there, Your Lordship. 1 to 4 are the official
to 11.
respondents.
I am
appearing for the
1 to 4.
5 to 11.
Nice.
So everybody is here.
Yeah, everybody is here. Your Lordship, my case is that, Your Lordship, the electric connection was there in my house, Your Lordship. And the respondent number 3 and 4, they disconnected the electric connection, Your Lordship. Without giving any opportunity of hearing to me, without issuing any notice, Your Lordship. Soon after that, Your Lordship, I approached to the office of the respondent number 4. From there, I came to know that upon the application of the respondent number 5, electric connection was disconnected. Now, who is the respondent number 4? Respondent number 5, Your Lordship. Respondent number 5 is the wife of one Manindranath Mandal. My father and Manindranath Mandal. Both are the brothers.
But the order says that it is under lock and key, nobody stays there.
Your Lordship.
Residual amount.
Keep it to my lordship. It belongs to us.
No, Your Lordship.
So that
It is. We were residing, Your Lordship. Your Lordship. Already there are the 3 states.
Sir, wait.
Yes, sir.
Are you still what is there? There is a house.
3 houses are there, Your Lordship. Plantation is there.
No. Where are your relatives residing? They are residing adjacent to you.
Adjacent to Your Lordship. Actually, what happened?
So if you do not reside there,
Your Lordship.
Who will consider these disputed questions?
Yeah, I reside.
Can you come to page 54? Place this order. Place the order. Good. Place the order.
Yes, sir.
Page 54. A complaint letter dated.
Yes, Your Lordship.
Place.
Must be clear.
No, sir. How
Yes,
can you
actually, Your Lordship, it is page 57, Your Lordship. A complaint letter dated 9/8.
Yes.
9/8/2004.
In my brief, it is 51. Your page initial shows it is anyway. Complaint.
Your Lordship, before I start, Your Lordship, something I want to say, Your Lordship.
This order says everything. You place this order now.
Yes, Your Lordship. Your Lordship, as per this order is furnished.
Please read the order.
Yes, Your Lordship. The complaint letter dated 9/8/2024 has been received from Shri Sanjeev Mandal, son of Shatendranath Mandal, residents of Netaji Nagar, regarding the resumption of electric connection in the house.
Your Sandeep.
Sanjeev Mandal.
Very good. In this connection, it is submitted.
So, for electric connection in his house, bearing the account number 1596, which is self-explanatory.
Yes.
In this connection, it is submitted that the account number 1596 was under the name of late Manindra Mandal, who expired on 27/8/2017, Your Lordship. As per the written request letter dated 12/4/2024, received from Saraswati Mandal, wife of late Manindra Mandal, stating that the post of expiry of her husband, the above said energy meter connection is no longer required. and the same may be dismantled to avoid the unwanted situation in future year. In view of the above request, the house site premises was inspected on 2024 and 29th April 2024. On the both occasion, it was observed that the house was locked and abandoned with nobody residing in the premises. Accordingly, as per the request received from the wife of the deceased, and on settlement of the final bill, white receipt number 231 so and so, the energy meter was dismantled on 15/5/2024. Further, on examining the instant complaint letter from received from Sanjeev Mandal, son of Satyendranath Mandal, residents of Netaji Nagar, and on inquiring the matter from the PRI member, the said Panchayat, it has been revealed that the matter is purely a family dispute, wherein late Manindra Mandal and the late father of complainant were brothers. Your Lordship, yeah. The complainant is therefore requesting the resumption of electric connection at his house, which is stands on the land of his uncle Manindra Mandal, Your Lordship. In view of the above highlighted facts, it is submitted that the department has no objection for providing the electric connection at the house of the complainant, subjected to the condition he shall apply for a fresh connection with the necessary document as per the prevailing JERC regulation in force. So this is the thing, Your Lordship. I made an application. My application was not considered, Your Lordship.
What application?
For seeking the electric connection, Your Lordship.
You want a new connection?
Yes, Your Lordship. Your Lordship, actually what happened, Your Lordship, when the electric connection was removed.
Was something that you are deciding there, na?
Yes, I am residing in the same house. I have enclosed the photographs. Everything is there, Your Lordship. Your Lordship.
How can you disconnect this way?
Lordship, he is not the recorded tenant of that landed property.
Where have you stated that?
Lordship, in the report itself, Lordship.
Whose report?
Report submitted by the junior engineer.
Okay, you don't give me a report, you don't give me a notice, you enter my house and stop.
No, he is not the resident of that house. Manindra Mandal is
That
the
is
name
how-
of Manindra Mandal. The meter was there.
Okay, very good. You should have given.
My wife has written a letter to the department, Lordship. His wife has written a letter to the department to disconnect the
They
connection.
were not in occupation.
Then why did you give, you found the house? You found
Here, he has made a application, so my junior engineer has narrated the factual
yes.
background and submitted it before the appropriate authority, Lordship.
So the meter was in whose name? In the name of.
Late Manindra Mandal.
Now the wife made a representation to you that I am not using it, you disconnect it.
Yes.
Nobody is
That
deciding.
you
Nobody
say,
is deciding there.
Old house, in also actually what happened, they are claiming the right over in that particular property. Just claiming, they are not in occupation. Now their intention
the
is,
connection does not give him right to the property.
yes, Your Lordship, but they are not residing there.
That is what I want to know.
Do is, they want to obtain electricity and then enter into the premises. This is the way to enter into the premises, they are doing all these things. They never resided in that property at all at any point of time.
Bring your letter, what you have written to them for this connection.
It is there at page 42, Your Lordship. Page 42.
Was there any inspection report?
Lordship, then I have to file my opposition.
Not opposition, bring your
Because in
inspection.
that particular letter, if Your Lordship would find.
Let us see, he has said that.
She has stated that they are in occupation, somebody is residing there. Nowhere she has stated.
Right. I want to see the inspection reports which you conducted. You may be in handing gloves with the private
No,
response.
no, Lordship.
Your Lordship, I am the owner of the property.
As per the-
It is a question of electricity, Mrs. Nag, it is not a question.
They are not in occupation.
That is your allegation, that is your allegation, let me say.
One person is in occupation of a house, he will be having at least one document to show.
Then why you are making that application after 3 years?
Husband expired.
Your husband expired in 2017. And the entire episode was completed within 7 days.
Your Lordship, I have submitted a representation.
After 7 years.
Yes. What happened, Your Lordship? one
Bring the letter, bring the inspection.
letter came to me stating that these were used.
Madam, this, yes, we will listen to you.
I was there in the, and there was no problem.
Hmm.
But the authorities, what they have done, they have issued a notice to me saying that these views are there.
Yes.
That letter came very late. So the women found that the views are there.
Madam, this way, you made the application. No, not evidently. I want to see the inspection report. How you can enter the house and disconnect? Whose presence you entered?
Electric bills are enclosed, Your Honor. Your Lordship.
Lordship,
Your office.
I will call for the report from the
Yes.
concerned
Yes.
assistant engineer.
Let them place the report here.
Hmm.
What my
I will ask them to bring the original record.
What my contention was
With
that
regard to this.
there are many houses. These house, Your Lordship, it is practically in a dilapidated.
He is a
condition.
bad man.
There.
He is nothing. He has no right. We are not concerned. I want to see whether any notice was issued in the name of this person or not.
No,
Not in the premises.
he is not residing in that premises. He is not the legal heir.
He is not the owner of the occupier.
From there. He is not the legal heir of Manindra Mandal.
How notice will be issued?
Why the inverter was continued for 7 years? Saraswati went on for 7 years. Death was in 2017. Incident she complained in
Since the
2020.
wife lordship, she has made application. We have gone there and she was ready to surrender the meter, so we have disconnected it. There is no malified intention on part of the electricity department.
That is what we have to ascertain. No? We have to see that
Let
inspection.
it be on Monday lordship because
The present,
bring the
yes,
original case
bring.
file.
The present petition has been preferred.
For the writ petition, my lord,
Hmm.
the writ petition is for.
Lordship, just I am praying for not today, just not today, Lord.
Not today.
Just not today.
This is electricity matter.
Yes, yes, yes.
And
Because
even on the last date and direction was also.
yes, I have gone through the writ petition, Lordship. I found that already estimated cost, everything has been done. Why they have not provided? Let me take instruction and come back tomorrow.
Tomorrow পাঁচ। এই কালকে রেখে দিন। Mr. Mishra, if there is any report pertaining to the records where Mrs. Nag is appearing, her application will also be there for that nobody is residing.
Everything. I will ask them to bring everything.
Please bring that record so that. Yes, next.
Item number 11. KP on of 125.
Your Lordship, I for the petitioner, the Honorable Supreme Court, Your Lordship has decided.
For appointment of arbitrator.
You
Yes.
request for the appointment is
Mr.
not
Chakraborty was asked to take
Take
instruction.
instruction.
How can I to allow their application on behalf of?
That is what the court thought, sir.
But how can department,
That is why you,
Difficult for us.
how can you are an officer of this court,
But
court
they are-
relies faith upon you.
we rely upon court, whatever the court will say.
So court has asked you to make an endeavor. See that it has not, the court has wanted to bring down the pendency of the matter.
But we know that the law is
What
against.
will happen, Your Lordship, even if we reach up to the stage of award, subsequently, if I challenge
Then
that
challenge the
award,
award, that will go.
that will go. What is the use of spending that much amount of money?
Please apply your good office. Then come, any agreed person can be here.
That's an appointment, Mr. I can suggest that Mr. Ajay Krishna Chatterjee can have been appointed. He is from the Bar Library, Calcutta. Anyone.
For that, we have to terminate the mandate, na? Unless we terminate.
Court can do, but
No, it appears from the earlier order passed that court reposed faith upon you and you will do something.
we have asked them, they said that.
You get it from them.
Will also be funded.
You can, it is not that you have to suggest, you agree to the name. On consent, we can dispose it of. Then you can ask your department already, give another person. If the court appoints, court has to appoint any practitioner or any ex-judge. Or we can appoint her also, but she is not appointed.
We don't have any.
Next Tuesday. Tuesday it can be done, or you,
But you can. In one session and go. And they are also.
no, you will not, okay. Question is if you agree upon an arbitrator, court on the basis of that will proceed. So that is a very, see if you can do so, otherwise we will hear the matter. Yes.
Item number 12. WPA to Superior Partner Day. Item number 12, my lord, next week. Service here for the faculty.
This is for hearing what service is required. Where is Mr. Jayapal? Dekhi, what is the matter about? What is the matter about? You are appearing?
For the administration, is main grievance is like platform is the company
State government interpret. You are for Union of India. So he is claiming regularization under whom? That is?
State government's company, we have formed that.
Yes.
Earlier there was an office of platform over here, he is employed with that platform office. We, union doesn't have anything in this matter.
Last time, my lord, we filed a service here for the patent, my lord, this matter. This time we have to this.
Sir, how long do you want to keep it pending? 2019 matter. Next Tuesday.
Matter number 13, WPA 135 of 2020.
Lordship, I appear on behalf of the respondent union. Lordship, on the last occasion on 17th of March, Lordship, the petitioner has made elaborate submissions regarding the award, Lordship, the impugned award, Lordship. We have to reply, Lordship. Lordship kindly keeps it in the next week, Lordship.
Moreover, my lord, there is an order of similar matters are there, my lord. In view, similar matters are there. In other matters, the coordinate bench, another bench decided that the matter be adjourned sine die till the matter is disposed of.
The
by
ONGC is pending.
my lord.
When is the next date, Mr. Guotagupta, before the Supreme Court?
Lordship, I am not aware, Lordship.
Last.
I am not. But Lordship, our matter is different from that matter. Lordship, Mr. Bhattacharya will submit. Lordship, kindly keeps the matter.
Conclusion, Mr. Guotagupta. Please ascertain when the Supreme Court has fixed the matter.
My lord, well, keeps it in the next week, Lordship. I will come back.
It's Wednesday.
My lord.
Acha, had Mr. Lal Learned Advocate appearing for the petitioner? Any paperbooks and everything were filed?
Affidavits were exchanged, everything was.
No. Only writ petition and supplementary affidavit.
You have filed a?
Only writ petition and a supplementary affidavit. Lordship, we will not file any affidavit in opposition. That is recorded in the order dated October 21st, 2020.
Then what do you want? You want to file an opposition?
No.
Then?
Lordship, we want to reply. Lordship, on 17th of March, Lordship, Mr. Lal has made elaborate submission that is recorded in that day's order sheet. Lordship, Mr. Bhattacharya is to reply, Lordship, but we are.
Next Wednesday. এটা ওনাকে ফেরত দিও।
And 14, WPA 97 of 2022.
There are two writ petitions on that. One I am for the petitioner, and another they are appealing for the. This is a challenge arising out of the award passed by the.
All records are there. We are keeping it on next Tuesday. You check up whether the records are there.
Item number 16.
My lord, in this matter,
WPA 133 of 2022.
last occasion, my lord, there was a direction to file paperwork. My junior was there, only 2 weeks time was given. My lord, labor code, entire evidence has to be taken, and I have filed a bulky bank statement and all, my lord. I seek 4 weeks time to file.
Mr. Kumar Learned Advocate appearing for the petitioner prays for the extension of time to file.
private respondent, fixed for hearing. The senior Mr. Govind appears in person as he is the member of that committee, which is the respondent in this matter.
Who is for the petitioner? Where is he? Where is he?
Yes, not today. Because,
You people will never do the matters. These matters are pending from 2020 to 2019.
Now it is ready for hearing. Last circuit, it was pending for some report from the administration, which is.
So he has sought for a prayer to conclude the pending proceeding. So who is for the, what objection you have to that?
Administration, I don't know. I don't have an objection. There is.
Who is for the administration?
Administration.
Rakesh Kumar. You are there, Mr. DLP?
No, but I'm not there in this matter. Rakesh is doing from previously this matter.
No, let it be on Thursday, my lord. Senior is available. I believe Mr. Kumar will also be available.
No, what for the petition is pending?
My lord, there was a revenue case pending before the SDM, Court of SDM, Sub-Divisional Magistrate. And the matter pertains to that. But however, the respondent authorities submitted their report. The documents of that report is not traceable. So matter went forth and back. And now at last it is fixed, like ready for hearing. Because
It is ready for hearing.
Ready for hearing. Just
Hearing to be done by whom?
start by the petition.
Who will be the officer? Proceeding is pending before whom?
Sub-Divisional Magistrate. File is not traceable, my lord.
So now file is traceable. So now the sub-divisional register will conclude that proceeding. Then
Tahsildar has already taken steps, by your last occasion coordinate spends, that Tahsildar to produce certain records which were brought on record. But the thing is that, well, if the petitioner is asking that file is not traceable. That report has already been done. Subsequent orders which has been passed in different RC case has been brought on record. That has to be put on for hearing. That's the whole case.
so what is this proceeding is still pending?
This file is not traceable. That's the whole. This is pending. The file is not available.
Where from do we get that? That file is not available. Who has told you?
Report has been filed.
Now this proceed.
The petitioner has filed a report on affidavit.
That the file is not traceable. So then the file has to be reconstructed then. Deputy Commissioner, who is appearing for Deputy Commissioner?
Tahsildar was directed to produce a report where he failed to do so.
Which advocate is appearing?
Mr. Rakesh is only appearing for the case.
If we say you are appearing in all matters, why not in this?
No, because this revenue department is, this department concern is a revenue department. For revenue department, generally, Mr. Rakesh appears or.
Where is he? Was here, Mr. Rakesh.
In this matter, Mr. Rakesh only appears.
He was just now here, no?
He was here, but not. It's gone.
His juniors are not here?
No. I can inform him, my lord, if your lordship.
Next Tuesday. Take a day off.
Hello.
Come back after. Come back after half an hour. You don't have any urgent matters also. Let them linger. Which matter do you have? None of the matters you people are ready. Where are those three matters?
On this item number 26, my lord.
What is the matter about? And 26 and
This is with regard to tender matter.
very good, I am coming back.
Not today, my lord, just tomorrow.
You start, you apprise us the facts.
Also, for that.
No, why tomorrow? You, who is your other side?
In one matter, Mr. Divedi is there.
Is there?
The one-
You people don't carry briefs? You do not carry briefs of the matters? Or it is kept at home so that you can pray for adjournment?
But yesterday also, so yesterday was holiday days from, I requested the department to send us the brief. Whenever I go to mainland, I give them the brief of the files and all. Whenever I come back, I ask them to send me the file.
And your department sleeps and you pray for adjournment. Sir, think about your status also sometimes. You are not a toddler in the bar. If you are handling a brief for your senior, then you must know something about the matter. This way, don't spoil your reputation. Please, please, high time. Our bar needs efficient advocates. Yes, I will return after half an hour. If you don't want to stay, you don't stay. That is up to the court to decide whether I will dismiss or allow.
And the petitioner in item number 19. These matters are flagged today. Mr. Tabriz appears in item number 18.
He must surely not be here. Madam, please shortlist any matter in which at least give some assistance, sir.
Sure, sure. We are, I'm going.
Any matter in which even otherwise it seems awkward now. Today you are having problem in here. I am accommodative, but please allow me some work at least.
Tomorrow your lordship will see that it is done.
Call করে যাও তো later. Then what do we do, madam, with this?
Let it be just not today, your lordship.
Again he will come and again he will pray for a job. Who is his junior? Nobody is here. The 18 you are appearing now. 18, 19 Monday রাখো তাহলে। And call the list any matter where both sides are there.
Item 20, WPF 485 of 20 and 21, I am appealing for resolution.
What is the issue?
Issue is, my lord, these petitioners on the basis of the selection process, on the basis of the approval accorded by the Andaman Nicobar administration, were appointed to the post of data entry operator and fuel under the district judge, my lord.
I see.
Way back in the year 2011. Since then, they are working continuously till today.
Yes.
Now, my lord, their such appointment was extended from time to time. I have enclosed all the orders. Now, my lord, I have filed this writ petition on threefold. First, my lord, there is an office memorandum of Government of India dated 7 June 1988, which says that if you are extracting the service, I am sorry to use this word extracting, the service of a daily wages employee at par with the regular employee, then they are entitled for the benefit of 1/30th of pay plus DNS announcer at the minimum of the relevant pay scale. Second, my lord, I say that since they are working for a considerable.
So it is equal work, equal pay.
Equal work, equal pay. My lord, Surinder Singh judgment onwards, the Nehru Yuva Kendra judgment, all those judgments will come into play.
You are there, Mr. Trivedi.
Yes, but I am only for the administration, the main part.
Who is Mr.
I am for the district judge, I am.
Then who is the person? Who is the
Administration is to give the funding, everything would be done by the administration. District judge is taking my service.
I will take the
On
service.
the basis of the approval accorded by the administration.
now at present they are in they are getting that
No, my lord,
contractual engagement amount.
they were getting lesser amount. Now, my lord, there were three prayers. First, they are benefit for the entitled for the benefit of 7 June 1988. Second, I shot for regularization. Third, my lord, what happened? The Andaman Nicobar administration on 22nd of September 2017 taken a policy decision. By under the dint of the said policy decision, Andaman Nicobar administration decided to give this benefit to all those who are discharging the duties of regular employee from 1st September 2017.
Very good. Who is the effective respondent? Who will answer this?
Money has to be given by them to the district judge.
Now any evidence have been used to this.
But they have not filed it.
Then how can we take it?
My lord, but I am ready, my lord, because my lord should not take me embarrassed, my lord. I am ready to do the matter.
Was there any direction for affidavit?
Yes, yes, there was direction to affidavit. District judge has filed the affidavit.
It appeared in the earlier bench also, it was adjourned. What?
During the pendency, my lord, they have given one of my relief was considered and given. From 2017, from retrospective effect, from 2017, they have accorded me the benefit of 1/30.
They have given you.
Given. One benefit has been given by the administration. Now, rest two are to be considered.
No, because there is one matter going on that is also in the single bench that traveled up to Supreme Court. And ultimately in Supreme Court, ministry said that we are not party before the High Court. Mr. Kumar is there in that matter. He is given liberty that you make ministry party and you go and you can go and file a case. Now, they have filed a case only on particularly on the regularization matter.
But ministry is a party here.
Not in this matter, ministry is a
Party ministry.
separate party. In that matter also, that is
No,
particular.
this is altogether different. This is altogether.
But that is also
This is
regarding the
altogether different.
regularization of all the employees of
This is altogether different.
all the employees
This
of
is
the
under the district.
territory.
Monday, yes, next.
Item number 22, WPS 619 of 2003 with item number 23.
Here, any is appearing, for the petitioner in front of you.
What is the issue? Same.
No, here there is an issue different.
You are for the petition.
No, 22, I am for the petitioner.
20.
Mini is the for the petitioner.
Not in 23, and for the respondent in 22, Mr. Padens for the. We are contending that this matter is not maintainable because they both have went to the civil court, they have filed their civil cases before the civil court. And they are paying more. Let us keep that or something.
Your opposition has been filed.
No, we don't intend to file. opposition.
You
This
prayed
matter-
for,
Yes, last. I agree.
Mr. Padens has said, in 23 they have not, 23 they have not.
what is the application? Can one?
But they are seeking for the injunction.
Taking extension of time to file opposition.
No, can, but in regard to the report submitted by the municipal council.
I don't know. What had been the previous episode? I don't know. You please check up the file and let me know. It will. You have got this affidavit in opposition?
No.
This is in the 668.
Private respondents affidavit in opposition, I have got.
Yes, yes.
Yeah, but government respondent, my lord, they are.
There is
I
a
don't-
private respondent means who is appearing for?
Many,
Oh,
many
acha.
is appearing.
So let it be tomorrow, let us see.
Yes, yes, ma'am.
Yes.
Item number 24, WPA 863 of 2023.
I am representing the respondent in this case.
What is the matter about?
We have filed an opposition in this case. I am representing the respondent.
Vijay Kumar.
Challenging the order passed by Deputy Commissioners. Therefore, imping order is page number 21, T1, T4.
Now what happened? You were
We have considered and rejected the claim of the petitioner.
opposition has been filed.
Fine.
Yeah, you have filed your opposition.
Yes.
আচ্ছা ভেরি গুড তাহলে কালকে রেখে দাও তুমি কল এবার লিস্টে কল করে দাও nobody is here.
Item number 25, WPA 878 of 2023.
Mr. Jaipal.
There was a direction to file affidavit reply.
No, I will not use this. Based on the material on record, I will proceed with the matter.
Very good.
Yeah.
You're sure affidavit not required.
Reply to Mohammed.
There is a private respondent also.
Take it three one after other.
And just
My application, let me proceed with the matter. First you said the reply, I said I'm not filing, then you say private response is there.
There are private respondents.
Yes, no.
Anybody represented them?
Mr. Anando Haldar appeared till last date of hearing.
Very good. You are not using any
No
reply.
reply.
So this will be first matter then tomorrow.
Yes.
What is the issue involved?
What has happened? These islands, time to time promulgated scheme of regularizing land in favor of encroachers. The last scheme is of 15th July 2003, which is exclusively meant for those landed property which is located within the border municipal limit. The precondition is, if a person is having a property recorded in or in her or his name, the excess land would be regularized under that 15/7/2003 scheme. For that, one has to maintain a continuous possession. There is no premium levied, it's premium free property. But one has to show is that he is having a property recorded in his name and he is having excess area. It's within Porter municipal limit and he is maintaining continuous possession. So far as land in question is concerned.
So you have to surrender the exceeding portion which
That excess land has to be regularized. There's no question of surrendering.
as per the scheme.
Yes, it's meant for pre-1942 category people of these islands.
Mm.
I'm pre-1942, I'm the descendant. I have maintained the excess land along with my recorded land. Scheme, in terms of the scheme, my case ought to have been considered, it was not done so. In the past, what has happened, the administration, that's Lieutenant Governor, issued a license in the name of private respondents area. That was challenged. This is for the 8th time before this court. That license was set aside by this court by Justice, Honorable Justice Nandam Sinha on certain grounds. The matter was dedicated back to the authorities thrice thereafter. 3 writ petitions were filed, order set aside. Now this is for the final stage. Again, the Lieutenant Governor issued a license in the name of private respondent.
So you are challenging the issuance of the said license.
Absolutely. I said since I am in possession, I fulfill the condition of the scheme. Private respondent is not occupying the land, so the action taken by the authority is very bad.
So this is under which provision of the regulations?
The scheme does not flow from this regulation.
You have annexed that
Yes,
scheme
yes,
here.
yes. It's 15 July 2003 scheme. I'll just show that. It has no legal, it's a policy decision, Lordship. I'll just show.
Is it annexed to the petition?
I'll just show. Give me some.
Anando Haldar appeared for the, yes, Anando Haldar 325.
Show this. Just give me some time. Lordship.
All right, yeah, we shall keep it tomorrow as the first. Manoj, এইটা কালকে আমার ওই যে মোশন টোশন নতুন কিছু থাকবে এটাকে উপরের দিকে তুলে দিলাম অ্যাজ এ হিয়ারিং ফার্স্ট ম্যাটার করে রাখি এই শুধু ফাইলটা আমাকে একটু বাড়িতে পাঠিয়ে এই ফাইলটা পাঠাতে ওই যে ম্যাচিং যেটা already you put Mr. Haldar on notice so that we can is sending an already Mr. Shial tomorrow it will be. Any matters where both sides are here?
One is
তুমি কল করে যাও Mr. you are there?
Back with the respondent.
Which one?
Item number 27.
And Vasanti.
What is the matter about?
Working under the DSL law. I've been issued with a termination order on the count that when I entered into the service, I have not disclosed about the pendency of the criminal case. No, there's nothing. On a fine day, it was served to me. By 12 noon, I was directed to be terminated.
Were you involved?
No?
Were you involved in a
The criminal case is pending under the Immoral Traffic Act. It's at the verge of disposal. So what I propose now. If the
termination is challenged here.
that has been challenged.
You are out of service since
I'm
when?
still in service. By way of the interim protection, I'm
Oh, you have gotten into it.
Yes.
You are continuing.
Yes,
So the termination is good or bad?
bad.
This is the issue.
May I say one thing? The lot other side takes the instruction because the criminal case is almost at the verge of disposal. If I'm ultimately held guilty in law, I can be terminated. If the jurisdictional magistrate court acquit me in lawship, then the order of termination gets evaporated.
Termination was on that sole ground.
Yes,
So when it is coming up,
it's challenged. Criminal courts matter. It's there not schedule as day-to-day hearing has been fixed.
but you are already under a protection.
It's there.
You are serving.
Yes.
So what order do you want from us?
I pray below.
We cannot terminate.
This
They
will
are
be disposed of only on the ground, it's subject to what my lord says, not that if the criminal court holds that I am guilty, then the termination order can be maintained. Otherwise, it can be.
And if it is, how can you stop the hierarchical proceeding of the matter? If the high district judge says not guilty, High Court may say guilty, Supreme Court may say not guilty. How will it be continued?
There I have no reply. There I have no reply. So there exactly I have no. I have no reply.
I can take.
Tell us,
instructions and come
madam.
back. I can take instructions and come back.
Very good. That's a good, she is assisting the court.
Because last occasion they told me. This same proposal was there. And when I placed it before the authorities, they said there's no issues. If they are convicted, we will terminate. If they're not convicted, we'll continue. That they also told me like that. But again, I have to take instructions, Your Lordship, because they may change at any time. We don't know.
So
It's not in written.
I can dispose of the writ petition only giving a direction to the effect that you termination will go once he is acquitted. But the thing is that the department may be agreed by that order also.
So I will take instructions and come back.
You do one thing, if you want to safeguard yourself, if you want any additional rider from the court, we shall incorporate and dispose of the matter.
Yes.
Come with a contention to that effect. Suppose, keep this in mind, if the district court holds against you, department may decide to go higher up. To that aspect, what can be your contention? Please let me know. On such line, I can dispose.
Yes, it's not an offense of moral turpitude, it's an immoral traffic lordship. I'm sure the state will not go for an appeal. To my understanding goes, it's not an offense of moral turpitude.
You are not the state, Mr. Jaipal. So when do we keep it? Do we keep it tomorrow? Very good.
Say only they will come to the.
Yes, Miller. এই 20 প্রথম ম্যাটারটা কি করলে this is which one 26 27 it will be fairly at the top then immediately after this we shall take time 27 টাকে উপরের দিকে করে দিই না হিয়ারিং ওটা একটা আছে হ্যাঁ Yes, Miss.
26, item number.
26.
Item 26.
This was the promotion matter you said, na?
Just not to remember.
Opposition is there.
We have filed
Pleadings are completed.
Pleadings are complete.
Oh, pleadings করে তাহলে এটাকে ওই টপে ফেয়ারলি এট দি টপ করে দেন অসুবিধা হবে 27টা তো করে দিয়েছো কল করে যাও 28
Item number 28, WP 80/2024 with item number 29.
Yes, Mr. Jaipal, I find many of the matters are yours. Make an endeavor if we can dispose of some matters. ঠিক আছে not to করে রাখো
Item 30, WPA 90/2024.
This matter may be placed before the next circuit bench because on the last occasion, this court has passed an order. Whereby, my lord, because this
passed an order
whereby in terms of the new rule, my lord, we were asked to approach the authority and we have approached the authority and the matter is pending. So, my lord,
so you came up against what?
No, the matter is pending before this court and this court passed an interim order whereby directed that.
Then to consider on the basis of the new rules, that decision is awaited.
Yes, my lord. And the entire procedure, how it is there, my lord. So the time has not lapsed. We have already applied. They have fixed a date for consideration.
I see.
And we are hopeful, my lord, it will be done. So let it be in the next circuit, my lord.
Then you are saying that in terms of that order, you made necessary application for consideration in terms of the guidelines.
They issued notice to me.
They issued
Notice, we appeared and the matter is now pending before them.
Final order has not been.
No.
Hearing is over.
Hearing, one date, hearing was done. We have placed the documents, my lord, before them. And hearing was done.
Mr. Kumar apprises Mr. Kumar learned advocate appearing for the petitioners. Submits that in terms of the earlier order dated 26th February 2025 passed by a coordinate bench of this court. The petitioner made necessary application before the respondent number 3 to consider his case in the light of the guidelines dated 30th August 2024. Pursuant to such application, the petitioner was called for a hearing, but the final decision of the said respondent number 3 is still awaited.
Yes.
Twenty-four,
Madam, for the respondent.
I'm waiting for the private respondent.
Mr. Khan is there, not today. What is the issue involved?
My lord, this private respondent, he never worked under the ICMR. I was holding the post of director in ICMR. He wanted a disciplinary proceeding to be initiated against me by filing the writ petition before this honorable court. And I am already retired from service.
He has been discharged, my lord. We have said that we have made the inquiry, find him not guilty and move, all the accusations are been rejected.
When the writ petition was filed,
At that time I was working.
He was
At the passage of time, I was retired from service. And he wanted that a disciplinary proceeding should be initiated against me.
How can that
Working
be
in the
done?
department, how writ petition will lie?
Mr. Kameshwar Rao is the person who wants the disciplinary proceeding to be initiated against the director.
Yes.
He is no longer in service.
No.
Director is not
Under the ICMR.
who never worked.
Kameshwar Rao never worked under.
So who is he?
He is some third person, my lord, working as a
The
DRM.
petition was admitted. Or it is the first time it is coming. It is for hearing.
Hearings are completed. We have filed our oppositions.
You inform Mr. Khan, we shall take it up tomorrow. উপরের দিকে করে দিন. Fairly at the top, 31. And Mr. Dwivedi also take the instructions so that.
We have, my lord, in fact, we have made all the inquiries and all, we found him not guilty. They have already challenged our order that he challenged our order that how you find him not guilty, you don't have authority to.
Who is the writ petitioner?
Writ petitioner.
That order was passed.
Now against him, you have not found him guilty.
No.
And
he is retired also.
He is retired also.
And that order was of 2017.
Already.
Challenged it in 2023.
Tomorrow.
And my lord, earlier one court has asked him posed a question to him that whether you can initiate departmental proceeding to a retired person or not. The answer is no, we cannot initiate a departmental.
Unless you extend the service.
My lord.
এই অর্ডার শিটটা একটু দেখাবে আইটেম 31 Has he filed any supplementary affidavit?
No.
There was a direction of 17th February. Will be fairly at the top. You inform Mr. Khan so that we can take it up.
Item number 32,
My lord, I am appealing for
WPN 93 of 2024.
I challenge the tender notice invited by the Indian Oil Corporation.
I follow this one.
Only for IOCL, you are for IOCL. You challenge the,
Tender notice floated by the Indian Oil Corporation for the purpose of assigning the job of security guard in airport authority, under the airport authority.
acha, then,
Then, my lord, I have challenged it on the score that this is absolutely illegal and arbitrary. The clauses which are there in the said tender notice are illegal and arbitrary, where, my lord, the rates are fixed. And the percentage, my lord, the whatever income, the percentage is also fixed, that 10% would be the amount which an incumbent has to apply. When you are applying, the rate is already fixed by the IOC. And
so who are you?
I am one of the person who is, this is with regard to ex-serviceman. I am also an ex-serviceman.
But you did not have the qualification.
So I have the qualification, everything is there.
Then you participated?
I participated. What happened, my lord?
You became unsuccessful.
No, I have not become unsuccessful. The thing is that everything was already fixed on the basis of seniority it was given. Now in their reply, they say that it was a mistake done. Hereafter, we will have on rotation basis. My lord,
Rotation basis in the sense?
the rotation basis in the sense, my lord, if my lord once come to page number 30. Once come to page number 30.
30?
30. This is the tender notice, my lord. Before that, page 29, my lord. Page 29. Notice inviting tender.
Yes.
My lord, may kindly see clause 4, estimate value of work. Got it, my lord?
Clause 4.
Clause 4, page 29.
29, we do not find any clause 4.
My lord, there are two writ petition. One amended writ petition may be seen, my lord.
It is
Amendment to have, yeah.
amended. Page 29, yes.
29. Clause 4.
Mhm.
Clause 4, my lord.
Yes, estimated value of work.
Estimate value of work 86,59191 for 1 year, including GST at the 18%. For 3 years, 2 crore 59 lakh. My lord, this rate is fixed. Now, my lord, may kindly come to page 30, clause 9. Rather, my lord, may straight away come to clause 10, my lord. Clause 10. My lord, may kindly see clause 10, subclause 4, my lord. Got it, my lord?
Yes.
It says the service charge of 10% as laid down by DGR will be strictly followed. Any security agency quoted other than stipulated service charge, 10% stand automatically disqualified from the tendering process. Now, my lord, this 10% is fixed. If a person quote 9 or 11, he is disqualified. Rates are also fixed. Now, my lord, may kindly see page number 43, the rates. Already I have shown to my lord in page 29. Now, my lord, may kindly see page 43.
No, 29, one was 86 lakhs and
Yes,
odd.
1 year 86 lakh with 18% interest, 18% GST, 3 years 2 crore 59. Now, my lord, can you see page 43? Page 43.
Yes.
Page 43, my lord, will find at the bottom. Total cost of 1 year GST at the rate of 18%, my lord, has seen similar. So, my lord, first ground of attack is, my lord, rates are fixed. Rates are fixed. Security agency quoting other than 10% would be debarred. So everything is fixed. Now,
no, 10% will be included within that.
No, before, my lord, less than 10%, more than 10% would be debarred. So this percentage is also
No,
fixed.
this service charge of 10% as laid down will be followed. Any security agency quoting other than stipulated service charges. What does it mean?
It means, my lord, if I quote 9% or 11%, I will be disqualified.
So that is included within this 1 crore 86,000.
Apart from that, this 10%.
Then what infirmity you are showing?
Infirmity is that, my lord, now, as per this, rates are fixed, percentage of benefit is also that 10%, this security, everything is fixed. Now, how the tender would be floated? Now, what is there, my lord? For ex-servicemen, there is a list of seniority list is prepared by the respondent number 2. Mr. Dwivedi is appearing for them. As per that, my lord, there will be list that these persons are in the said list.
Zone of consideration.
Yes, now my lord, kindly see clause 3. So already list is there. Now my lord, page 30, clause 3 may be seen. That is 10 sub clause 3. Kindly see. If in the eventually of all the Rajya Sainik board sponsor ESMs quoted the same rate, the contract under consideration will be allotted to the senior most sponsor ESM. Now, so far as the rate is concerned, rate is fixed. There is no departure from that. So whoever is senior, he will get it. Nobody else will get it. Now, my lord, instead of my lord going much in the documents, my lord may kindly come to the opposition filed by me. They fairly admitted, my lord, this. My lord may kindly come to the opposition or.
Now, Mr. Kumar.
I will show one paper thereafter, my lord may kindly consider it. Because the issue, what I am placing, they accept that. The Indian Oil Corporation accept that page 9 of their opposition last 2 lines. Last 2 lines. Now, my lord will find the response number 2 by their letter dated 10th November 2023. Clarified that the seniority list henceforth will be on rotation basis for each fresh tender. So, my lord, they are accepting that on the basis of seniority. My lord has seen this clause 3 and 4. Rate 10%, everything is fixed. Now, seniority is the criteria which governs the affair. Now, as per seniority, the person who is first, he will always get the tender, we will not get the tender. And that's why the Indian Oil Corporation says that after this, it would be on rotation basis. So they are admitting that these are the criteria because of which my right was affected. Now, my lord may kindly see the list and that letter, my lord. My lord may kindly come to page 82.
But what happens now? That is already over.
My lord, because I approached this court. When I approached this court.
Did you get any interim?
No, I didn't get any. My lord, why I didn't get an interim order, my lord? Because it is from Calcutta. Justice Mosmi Bhattacharya has taken this matter.
No, but Mr. Kumar, suppose you are right. Presumably you are right. In that case, what relief do we give?
My lord, kindly appreciate the situation when I filed.
But today we cannot throw out the person who has already been inducted.
No, that is also a party in the proceeding.
So maybe his work has been done away. In fact, the petition is at an infructuous stage. We cannot give you any relief.
But my lord, may kindly.
What relief did you pray for?
My lord, may kindly see. To satisfy. My lord,
You should
appreciate the situation. I have approached the court in time. But because the service, because they are from Calcutta, when I sent it took 2 to 3 days.
But we understand, Mr. Kumar, but now the water has flown through the Ganges. What relief? We can keep in open for you for approaching the civil court for compensation.
My lord,
My
lord may kindly see page 9 and any order may be passed in the light of that.
Page 9.
Page 9 of their reply, my lord. What I have read just now.
Yes, that they are admitting yours.
Yes, but they are saying here and after it would be on rotation basis. My lord, at least this tender, if I didn't got, at least next tender, because I am there, my name is there. My name appears.
No, that is fair, Mrs. That is fair.
That is fair. The only thing is that, though it is written in respondent number 2, by the letter dated 10th November 23 clarified that seniority lists henceforth will be on rotational basis for each fresh tender.
That is page you are reading, page.
Say page 9, last line.
Yes. Yes. So you are saying this is not an admission?
No, I'm not saying. You are not saying. It's so clear.
That letter is also there at page 8.
No, we shall clarify, Miss.
I think then 2 minutes pass over. I can give consent over this particular. I will ask them, but you yourself has written. So hereafter the rotational basis will be followed. Or else your lordship also can pass the order on the basis of this particular. This thing is no.
Otherwise,
But in the future tender process, we can, I cannot say that you will follow this in the, I don't know what changes in the next tender process.
Because immediately after this tender, because 1 year has crossed. Now the next tender, whether they have followed the rotational basis or not, that I don't know.
This is with regard to ex-serviceman. It is not a simple tender where everybody can participate and everybody can be allocated with the. No, this tender is for ex-serviceman. They are governed because this name has to be
That
given.
protection we will give you.
My
You will
can you
need
see
that.
page 87 once, my lord. This is given by Rajya Sainik Board. That which I have read, my lord, at page 87, my lord, may kindly
No,
see.
Miss Nag, why don't you do this thing? If they will either tell you two things. That first is don't record that observation of hours in the affidavit because terms of conditions may change in the future. But when it pertains to the seniority list of a particular organization, which will remain as it is, because when you will give, you have to follow that on the rotational basis. Kindly take that instruction, or you can bring a written instruction to the date on that basis we can distribute.
Difficult, you know, because they are in Calcutta.
So very good, you obtain that verbal instruction. Yes, by mail, let him send that in future tender processes, we would be following this, as we have affirmed before the court. But so far as his claim is concerned, that will not be, he will be successful in this. But tell me, when do we keep it?
But my lord, can you consider this aspect, my lord? This entire episode is illegal and arbitrary, my lord. I am not on time. I say, my lord, when everything is fixed, then what is the use of calling the tender? You give it to the senior most person.
Suppose you are admittedly not the senior most person.
I am not admittedly.
So what you are challenging, if your enter tender goes, question of your getting involved does not appear.
My lord, I say.
It is like digging your own grave.
No, my lord, what I say, my lord, if seniority, if everything is fixed, then in that case, my lord, this is absolute arbitrary and violative to the fundamental right to have a fair competition in a tender process.
No, that is not, you still you do not come within the zone due to the seniority. Mr. Kumar, if everything is fixed, still you do not come within the zone of seniority.
My lord, that rotation basis.
No, rotation basis is today I am the senior most. I get the tender. Next tender, my next junior will be getting it. How you come within the zone if seniority remains to be a criteria?
There, the cost is the estimated cost. It is not fixed. Yes, it's estimated. The word is written estimated. So you can give.
Sir, tomorrow একদিন top করে দিও, টপে রেখে দিও. You come with that instruction or we hear it out finally. Chalo. Yes, any other matter will. Yes.
Draw the repetition.
Item number. আচ্ছা একটা একটা করে কল করে যাও. This was item 32. 33.
33 WP at tricolon of 24.
And we have already filed our opposition block, but I don't see the order March 12, 2025. It's written that affidavit in opposition, time to file affidavit in opposition.
Is your other side?
I'm
Have you given a reply?
No, I'm not fighting.
So, this,
Item number 33.
I filed.
Do you have the affidavit with you now? Original? Then what you are saying is a mistake.
Time to file affidavit in opposition is extended till this case. But there is fact against that which have already filed our opposition.
Somebody must have been there.
The registry of come to this on the.
Doesn't matter. You give your reply. When will you give your reply?
Within this week, next week, this can be taken.
So keep it on next Tuesday. Ilon, Manoj, item 33 take next Tuesday করে দাও. Or Friday we give. Can you do
On Friday. On Friday. On Friday.
item 30? We shall, when we will accept that, we will make direct. 33, yes. এখানে একে ডেকে পাঠাও. We have a,
Draw the repetition.
which one? 50.
Yes.
Who is your other side?
Mr. Shivapal.
I am representing the respondent.
On last occasion upon my mentioning the matter of what was into this, but this court directed me to file an application for withdrawal.
That you have filed.
That I have filed it, not can take that can application on base this matter.
What is the can number,
The
sir?
number has been allocated to the one of 2025.
তাহলে মনোজ ওটা আমি রাখি 50টা হয়নি এখনো. তাহলে এটা এক কাজ করবো, তো ওটা যদি এসে যায় এইটাকে ডে আফটার টুমরো টপে দিয়ে দেবে ডে আফটার
Right, right.
আন্ডারস্টুড